We're the mobs who ask the questions, digging deep, no second guessing. From the school run to the crime scene, truth and chaos, we're the dream team. Bad Kids Club, yeah, we ride or die. Sad eyes sharp and our standards high, brought together by FKR. Now we're taking truth real far, and we're just getting started. Talk time with Amy, Boston, and Kelly, spilling facts that hit your belly. Partners in crime, fueled by conviction. Moms on a mission with sharp intuition. Talk time, we're calling out lies with caffeine, chaos, and side-eyed vibes. It's raw, it's real, it's how we vent. Leaning close, let the reckoning commence. This is Talk Time with Amy, Boston, and Kelly, where the tea is hot and the truth cuts.
Clear repeatedly that this case will go to trial sometime in 2020. Yes, Judge Diane Frenier was appointed to this case just 3 weeks ago, and she said during the hearing this afternoon that she doesn't want to rush either side, but she made clear repeatedly that this case will go to trial sometime in 2025. Now, it's already been nearly 2 years since Anna Walshe disappeared. The mother of 3 from Cohasset, her body has never been found. Authorities have accused her husband, Ryan, of dismembering his wife and disposing of her remains. He is charged with murder. Now, Walshe's attorneys are asking for emails and text messages from the lead investor on the case, Trooper Michael Proctor. That name may be familiar because Proctor was also the lead investigator on the Karen Reed murder case, and he wrote insulting messages about Reed. Now, Walshe's attorneys want to see if Proctor wrote any similar messages about him. Today, the judge set several hearing dates and a trial date now of October 20th, 2025. The prosecutor told the judge that he expects once that trial begins, it will last approximately 4 weeks. Live in Dedham, David Bienick, WCVB News Center 5.
I'm Vinny Politan. The subject of my investigation is the disappearance of Anna Walshe, the mother of 3 young boys. Investigators have not found her, but they believe they know what happened and who is responsible. Here's the story. Anna Walshe was born in Serbia in 1983. After graduating from a university in Belgrade, she eventually moved to the United States in 2005. She became a dual citizen. Anna worked in the hospitality industry at various hotels, and it was at one of those hotels where she met Brian Walshe. In 2016, Brian and Anna got married and started a family. Together, they were raising 3 young boys. In 2022, Anna obtained a position with a real estate company, which forced her to split time between her home with her family in Massachusetts and Washington, D.C. This move, along with Brian's federal indictment related to an art scam, put a lot of strain on their relationship. Then, after spending New Year's having dinner with friends, Anna seemingly vanished. She was reported missing by her employer in D.C. and by Brian on January 4th. Investigators suspected Brian and ended up executing a search warrant, which uncovered evidence they believe proves Brian murdered and dismembered Anna, despite the fact that her remains have never been found. Brian has been charged with Anna's murder and is locked up waiting for his trial. Think about this story and Anna Walshe, 3 young kids at home. Where did she go? You know, we've seen this fact pattern, unfortunately, several times before through the years here at Court TV. A couple with young children, and all of a sudden, someone goes missing. Usually it's the wife, the mom. So why do prosecutors believe that Brian Walshe could do this? Well, I want you to take a listen to the prosecutor at Brian Walsh's arraignment, talking about Brian and Anna and what was going through the mind of the accused killer.
In December of 2022, it had become evident that Mr. Walshe was suspecting his wife of having an affair. He was routinely visiting the Instagram page of one of her male friends, and on December 26th, his mother, with his input and direction, obtained and hired a private investigator to surveil Anna Walshe in Washington, D.C. On December 27th, the oldest son's iPad was used to research best states to get divorced in and worst states to get divorced in.
A private investigator suspected that something was happening here? That brings us to our first question in this investigation, and it's about the Walshes. What was going on in their relationship? And how would that be connected to any potential motive for murder? Joining me to help figure all this out, longtime reporter in Massachusetts at Boston 25 News, Bob Ward is with us, and the host of Talking Live and the Bite Size podcast, a psychotherapist who wrote a book on killer spouses, Dr. Robbie Ludwig. Great to have you both here. Before we dive fully into this, I just want to put one more thing out there. And this was the paramour, the alleged man that Anna was seeing, speaking with police. And this is January 7th, 2023. So it's about a week into the investigation. And you may recognize this name, Sergeant Y. Buchanan, which is Yuri Buchanan from the Karen Reed case. And Detective Lopes traveled to Washington, D.C. and spoke with attorneys that represent, and we've redacted the name of the alleged paramour, who resides in D.C. and is the most frequent contact with Anna on cell phone records in possession of investigators. So they're talking a lot on the phone. Statements to investigators is that he was in a dating relationship with Anna Walshe and had been for several months. The relationship became more serious over the past few months, and they had spent Thanksgiving together in Dublin and spent Christmas Eve together also. They were open about the relationship in Washington, D.C., and they had plans to celebrate the new year on January 4th, 2022, after she returned from Massachusetts. Okay, Bob Ward, it seems that this was a strained relationship, and a couple things in play, right? The fact she's got this new job out of town, and he's got this indictment.
Yeah, the indictment, you can't overstate that enough, as being a major role here in what was driving that wedge between them. He had the indictment for selling, a federal indictment for selling fake Andy Warhol prints. He was looking at serious jail time, substantial fines. You know, going back even further than that, he also had issues with his father, who passed away, and issues over his will. And it just financially, he presented as somebody other than who he was. So he presented as somebody who was well off and connected, when really he was just scrounging for money. This is according to the prosecution. And he was putting up this false front, and he could not afford the lifestyle that he would try to portray himself as having. But there was even trouble before that. Vinny, back in 2014, while they were still dating, she told police down in D.C. that he threatened to kill her and all of her friends, but she stayed with this guy. And, you know, that relationship may have been open down in D.C., but it certainly was not up here in Massachusetts, where he was on house arrest, waiting sentencing for that federal case. And in December of 2022, he caught wind of what was really going on, and that sent all these events in motion.
All right, Dr. Robbie Ludwig, let's talk about this and how it could be connected to a potential motive. What goes through the minds of a spouse, of a husband, of a father? He's got, on the one hand, he's facing federal prison time. On the other hand, his wife is doing very well in her career and seems to be creating a new life for herself in Washington, D.C.
Well, you know, clearly Brian was a person who did not feel good about himself, had a very abusive history, and felt like who he was not good enough. So he meets this woman, he convinces her that he's the successful guy, and over time, his wife finds out who he really is. Somebody who is not wealthy, not successful, and has a hard time actually making a legitimate living, and she finds somebody else. And what we know about abusive relationships, when a woman plans to leave, that it triggers something within the husband, where a husband can become homicidal. They're dependent on the wife, but they don't want that wife to live if they are not going to choose them. And it sounds like that's what happened here. The wife was moving on. He knew it. He knew his life was falling apart. And this is what he did in order to both punish her, most likely, allegedly, and also to get some money, which he was in desperate need of.
I want to put this up on the screen as well. Anna's good friend also spoke with police. Here's from the report. Investigators spoke with Anna's friend, name redacted, and learned that the marriage between Anna and Brian was strained. Anna was planning on having the kids live with her in Washington, D.C. Anna had reportedly given some sort of ultimatum to Brian about the resolution of his criminal case with the federal government and wanted the kids to be with her. When investigators viewed Anna's residence in Washington, D.C., they observed it to be ready for the kids to move there with clothes and other items available. So, Dr. Robbie, it seems like this is exactly what you're talking about. This is the moment where she has made all the preparations to leave him, you know, physically, go to another state, and relocate the children with her and start some sort of a new life without him, because on the one hand, he's going to prison for the scam that he was running. And on the other hand, she doesn't want to be with him anymore.
Right, and exactly. And this is the moment where, in Brian's mind, Anna is bad. She is the rejecting woman who is leaving him, who is plotting and finding a way to have a new family without him. He is being left. And that is just unacceptable. And the rage that he feels for Anna treating him the way he feels that he really is, this worthless guy who isn't worthy of a relationship. So instead of taking responsibility and owning that, he kills the woman who has found him out to be, you know, a loser, basically, and has chosen another man and chosen, you know, to raise his family with somebody else. That was just an unacceptable scenario in his mind.
And Bob, you look at the scenario. I mean, it seems like she had already moved on in her mind, right? Like she's out of there.
Yeah, it does look like she was out of there. She was making her plans. She had a new place to live. She had a new guy to spend her life with. She knew she was going to take the kids somewhere else. But I think there's also evidence that Brian was not aware of this. In the days before the murder took place, he starts Googling those questions about divorce. But what I'm thinking about is, what I always have a hard time wrapping my head around, is that party, that New Year's Eve party. The police found in the dining room, they found a box for a champagne bottle, where Anna wrote a message to Brian and said, "This year is going to be our greatest year." So, word to that effect. "I love you. Everything's going to be great in the new year. Let's make things better." So she had not had that, I don't think, had that conversation with him that she was going to leave. So, you kind of wonder. She was getting things ready, but there was no date for sentencing yet. In fact, he was only sentenced this year, and he got 3 years. He has to pay, I think, $475,000 in restitution. So there was still time. So it's going to be interesting when this trial takes place to find out what that dynamic was, what happened at that New Year's Eve party in the hours before she disappeared.
Absolutely crucial. All right, folks.
I just want to say that
we're out of time, Dr. Ravi. He knew. You're saying he knew.
He knew.
He's got the sense that he knows. All right, Dr. Ravi, thanks so much for going to stay with us. Coming up next, what are the details behind Walshe's art scam?
In 2001, Anna Walshe had taken out approximately $2.2 million in life insurance on herself, where Brian Walshe is the sole beneficiary. And as a result of working at Tishman Speyer, she has an additional more than $400,000 life insurance policy where he was the sole beneficiary. In total, her life insurance is over $2.7 million, where the defendant was the sole beneficiary. Your Honor, as a result of the extensive investigation that was done into this case, the defendant's grave incentive to flee of being charged with murder, and that he has one open matter, I would ask that the defendant be held without bail.
So being held without bail, he had the issues here, obviously, with what happened to his wife, Anna, but also another outstanding matter. This was the matter involving this alleged art scam that he was running. Take a look at this. This is from the U.S. attorney up in Massachusetts. February 24th, 2024, a Lynn man, that's Brian Walshe, was sentenced today in connection with a years-long, multifaceted art fraud scheme involving 2 purported Andy Warhol paintings. Brian Walshe sentenced to 37 months in prison, 3 years of supervised release, also ordered to pay restitution of $475,000. In 2021, he pleaded guilty to 1 count each of wire fraud, interstate transportation, scheme to defraud, unlawful monetary transaction. So that brings us to the next question in our investigation, which is about him and his scam. What are the details behind Walshe's art scam? What was he doing here? Still with me, reporter for Boston 25 News, Bob Ward, and joining me, Massachusetts trial attorney, served as special counsel to Johnny Depp in his defamation case. Wayne Dennison is with us. Okay. I don't know where you guys go to buy your art, but this is some art that was apparently purchased through eBay, but it was Warhol's. I want to put them up on the screen so people know what we're talking about. One's real, one's not. We have 2 different ones to show you. Let's take a look at the first one. The one on the left, not real. The one on the right, real. So you got the fake on the left, the real on the right. We have one more that I want to show you. The fake on the left, the real on the right. These are, well, one of them in each set is an actual Warhol. The other is what this defendant was apparently selling. Wayne, let me start with you before I get into the details of exactly what he went through and did here. How serious of a case is this? Because this seemed to be a big black cloud hanging over his head and the marriage with Anna.
It's a very serious case, and it's been pending as a black cloud for a very long time. This goes back to 2011, where he got the paintings, the original paintings, allegedly from a friend. But this thing has been going on and on and on and on. You're talking about a sale that was made in 2016. We're all the way to 2023 before he gets sentenced.
It's fascinating to go through what he did. And this is what he did. 2011, as Wayne said, he's visiting a friend in South Korea, and he convinces him that he could take a couple of his Shadows collection from Warhol's 1978 paintings, telling the victim he could sell the art for a good price. Then the victim comes across two paintings purported to be from this collection on eBay for $100,000 with a purchase price, and he's got an invoice for it because he got the invoice from his friend. Then in November of 2016, the buyer negotiates with Walshe and buys them outside of eBay for $80,000. But then the buyer's assistant flies up to Boston to get the paintings, gives a cashier's check to Walshe. He deposits it, takes money out, but then the buyer a day later takes a look at the actual paintings when they come back and realizes that they have staples and new canvases and don't have the authentication stamps. Walshe sort of avoids the guy, and it turns out that the original paintings were sold way back in 2011, and he had done the same scam in 2015. Bob Ward, how is this guy just running scams? Is that his career? Is he like a career scammer? Did he have any legitimate job?
It doesn't appear that he did, or if he did, he wasn't making much money from the jobs. You know, I've met over the last couple of years since this news broke. I've talked to plenty of people who told me they knew Brian Walshe, and they spent time with him, and they said that they were taken in by him. He was very gregarious, and he passed himself off as being a very wealthy man, and they totally bought it. We're talking about intelligent people just talking about their interactions with the guy. The thing that blows me away, Vinny, is that you got $100,000, tens of thousands of dollars people are spending, and they're not verifying these things ahead of time. You know, it really is surprising. But he's in that world, and he was in the world, you know, here in Boston, you know, Beacon Hill, and rubbing shoulders with some very powerful people from time to time within various industries up here. And so he knew how to move in that world, and he knew how to present himself. But he was a fraud, an absolute fraud.
And you know, Wayne, when you're in trouble with the feds already, you've got all these other things happening. You realize you got away with the scam for a while, but not forever. What are your thoughts about, you know, the fact that he was already, you know, on house arrest when all this stuff is happening? Are you shocked? Are you surprised that he's allegedly made the leap from being a scammer to a killer?
Well, it does seem that this was financially motivated. So you start with a scammer who's trying to make a buck on the side, you know, lives in a very affluent south of Boston suburb right along the water. And you start with that, and now there's $2.7 million in life insurance out there. And it does seem to be the next leap. And boy, it's a horrible leap, but it appears that he took it.
And, you know, Bob, when we talk about this couple, Anna, very successful in her own right, like very, very successful in her own right, building a career, coming to this country from Serbia and building a great life. And I wonder if she felt like she had gotten scammed as well by the art scammer.
It does appear that way. And also don't forget this other issue with his father and the inheritance and the allegation that he basically stole his dead father's house out from underneath the estate. And that's part of all this too. His dad had money, and he wrote off his son because he felt his own son was a scam artist. So there's all of that swirling around. You know, they're saying that this trial may last about a month, but I wouldn't be surprised if it goes longer because there's a lot here for prosecutors to dig their teeth into when they start presenting these facts.
Yeah. What are your thoughts, Wayne, about any of this scam stuff making its way into his murder trial?
Well, I think you're going to have to prove a motive, and this scam stuff will be reflective of that motive. And I do think it will get heard in the murder trial. There's in every likelihood, you're going to hear that story as the precipitating factor in this ultimate crime.
Yeah, it's unreal. Like, you're living a fake life. You end up with a beautiful wife who's very successful. You got 3 beautiful kids. From the outside looking in, you're living the dream, but it was all fake. All fake. All right, folks, coming up next, what is the evidence against Brian Walshe?
Tom.
I'm Vinny Politan. We continue our investigation of the disappearance of Anna Walshe, a mother of 3 little boys. Anna was born in Serbia, but became a dual citizen, living the American dream with a beautiful family and an amazing career. All that ended after New Year's in 2023. Here's the story.
Brian Walshe seemed like he was a wealthy, successful businessman until he got caught up in a major art scam. The feds indicted him on charges of selling fake Warhol paintings. At the same time this was happening, his wife Anna was doing extremely well at work. She landed a lucrative position with a realty company that had her splitting time between her home with Brian and their 3 boys in Massachusetts and Washington, D.C., where her employer was. The federal indictment and the commuting to work put a strain on their relationship. Then things went really bad when Anna seemingly vanished after New Year's Eve with friends in 2022 going into 2023. The investigation resulted in the arrest of Brian Walshe for the murder of Anna, and he is now locked up waiting for his day in court.
And while he waits, he claims his innocence. He's saying he did not do this. I want you to take a listen to his defense attorney, kind of laying out clearly what the defense will be here.
Your Honor, it has been 4 months since Anna Walshe has last been seen. It was on January 1st of this year. As Your Honor knows, under Massachusetts law, about a person is not considered dead because they're missing for a period of 7 years, because it is easy for a single person to disappear if they want to disappear. In that 4 months, there's been no body found. There's been no indication of if she died, how she died. There's no murder weapon. There's no motive.
No body, no motive. So that brings us to the next question in our investigation. Defense was talking about what they didn't have. So what is the evidence against Brian Walshe? How are they going to prove without a body that he murdered his wife, Anna? Joining me, longtime reporter in Massachusetts at Boston 25 News, Bob Ward, and retired Army intelligence officer, former NYPD officer, and now a private investigator, Manuel Gomez is with us. Great to see you both. Let me start here, Manuel. Your thoughts about the fact that they have not been able to find her body?
Well, unfortunately, they've not been able to find her body, but the evidence is still overwhelming against Mr. Walshe. You got to remember, they found on his son's iPad evidence showing that he was looking up how to find stuff to clean up on a crime scene, how long it takes before you're missing, if a body's missing, and so forth, when it's reported. And not only that, but he also lied. He lied numerous times to the police saying where he was. And he said he was only at a coffee shop when it shows him at Home Depot buying cleaning products, over $450 worth of rags and so forth. So no, unfortunately, the body is not going to be given up by him, but in due time, I think he will.
Well, let's do this. Let's take a listen to some of the evidence that prosecutors believe they have in this case.
Mr. Walshe had told the babysitter that he and his wife initially were going to go out for a late brunch, New Year's Day brunch that day. But then he told the babysitter that Anna Walshe had returned to Washington, D.C. That morning at approximately 6 a.m. for a work emergency, and that he needed to visit his mother in Swampscott, and asked the babysitter to stay. He had also told the babysitter and the family friend that he had lost his phone, and he had told the family friend that he had felt somewhat free having lost his phone. Subsequent analysis of his phone determined that it was actually plugged in the morning of January 1st. At that time, where the phone is showing that it's at Lowe's in Danvers, the defendant walks into Lowe's in Danvers by himself on store surveillance video. He is seen purchasing numerous items, including 5 Lowe's 5-gallon buckets, a Lennox high-tension hacksaw, 48 terry cloth towels, a framing hammer, Tyvek full coverage suit, shoe guards, mop, snips, 200 disposable rags, trash bags, Murphy oil soap, and other cleaning products. It then travels to CVS in Danvers, where Mr. Walshe is again seen on video by himself purchasing 13 different types of hydrogen peroxide. It then travels to Stop and Shop in Swampscott, where Mr. Walshe can be seen buying 3 64-ounce jugs of ammonia. From 2 a.m. to approximately 5:30 a.m., the oldest child's iPad searched and visited websites concerning instructions on how to clean blood and DNA from objects, how to remove SIM cards from phones, how to mix ammonia, and search for apartment complex in Brockton, Massachusetts. At 8 a.m., the babysitter returned to the Walshe residence. Mr. Walshe left the residence that morning and is on surveillance at Home Goods in Norwell, purchasing 3 area rugs and scented candles. The babysitter would state that by the end of the week, she had noticed that the downstairs area rugs had been replaced, as well as a kitchen trash can. On the afternoon of the 3rd, Mr. Walshe visited 3 different apartment complexes in Abington and 1 in Brockton. Video from these complexes captured Mr. Walshe in the area of the dumpsters for 3 of these complexes. One video showed him looking into a dumpster and not putting anything into it. A second captures him taking items from his SUV by the area of the dumpster. And then the third depicts Mr. Walshe depositing a bag that appears to be heavy into the dumpster. On January 4th at 10:04 a.m., the person that Mr. Walshe had texted the day before responds to him and asks if he has heard from Anna. 10 minutes later, Mr. Walshe then calls the building that Anna Walshe worked at in D.C. and reports her missing. 5 minutes after that, he texts back to the friend and says, work is looking for her.
Bob Ward, as we take a look at the evidence and the timeline of this case, a couple of things. One, the fact that he's had no communication with his wife for 3 days, then reports her missing. That's odd. And then all these little trips to the dumpster, and like Manuel pointed out, the purchasing of these products just out of the blue.
Out of the blue, and I think he's wearing a device, an ankle device, because he's still away. He's on house arrest for the federal charge, so they know exactly where he's going. And if they don't, he lied about at some points that he was saying he was over here when he was actually over there. No, it's all very damning. But one of the main things here to remember is that the Commonwealth is going to try to prove a first-degree murder case without a body. Now, it's not impossible, and you hear much of this evidence, and it seems overwhelming, but they would really like to have the body. And the reason that they're saying that there's no body is that the dumpsters that he used were in 2 different parts of the state. The ones in the southern part of the state, where he was seen dumping that heavy bag, the bag containing something heavy, and he struggled with it, that went to an incinerator near Cape Cod. All of that stuff is gone. But the dumpsters that were on the North Shore up near his mother's house, the police were able to find some of those items, including a hacksaw. And they're trying to get DNA from that hacksaw to prove once and for all that Anna Walshe is dead. That hacksaw is one of the hacksaws that they saw him buy, I think it was at a Lowe's up on the North Shore. They saw him buy that hacksaw. That's the hacksaw they say they found, and now they're still working to try to determine DNA if she is on that hacksaw.
That would be crucial. Let's take a listen, Manuel, to more of the information regarding these Google searches that he allegedly made.
At 4:55 a.m. on January 1st, he searched how long before a body starts to smell. At 4:58 a.m., how to stop a body from decomposing. At 5:20 a.m., he searched how to found a body. At 5:47 a.m., 10 ways to dispose of a dead body if you really need to. At 6:25 a.m. on the 1st, how long for someone to be missing to inherit. At 6:34 a.m. on the 1st, can you throw away body parts? At 9:29 a.m., what does formaldehyde do? At 9:34 a.m. on the 1st, how long does DNA last? At 9:59 a.m., can identification be made on partial remains? At 11:34 a.m., dismemberment and the best ways to dispose of a body. At 11:44, how to clean blood from wooden floor. At 11:56 on the 1st, luminol to detect blood. At 1:08, what happens when you put body parts in ammonia? At 1:21 p.m., is it better to throw crime scene clothes away or wash them?
You know, Manuel, when I look and listen to that evidence, it tells me two things. One, the timeline of when she likely died, because we start talking about when does a body start to smell, but also, I don't think this was something that was plotted and planned. It seems like it's something that just happened, and he's doing all this stuff after the fact, trying to cover up his tracks, as opposed to planning how he was going to murder her.
I agree. And not only that, but I thought it was, quite smart on his part that he broke up the places where he's going to drop off the bags. The fact that he bought that hacksaw, all right, cutting the body up, and she was a small woman, she wasn't a big woman, would fit her into one bag if he cut her up in 5 pieces, which he most likely did. And the other thing is that the fact that it went to an incinerator, the average incinerator for these trash facilities are between 1,800 and 2,000 degrees. To cremate the body and cause it into come ashes, it has to be 1,500 degrees or higher. So, of course, like Bob Ward said, the evidence is completely gone. But this guy clearly planned it at the last minute, judging by the timeline. But, again, this is a professional con artist. And I want to say, Vinny, I blame the courts for her death. You know why I blame the courts? Because, Vinny, she was living in a house with a man under house arrest who was already found guilty for selling pictures of and stealing money, and they did not put him in jail. They dragged it out for a couple of years. This man should have been in jail for the crimes of the Andy Warhol pictures, and he wasn't, and she'd still be alive. So, unfortunately, I blame the courts for this one.
That's a great point, Manuel. Manuel Gomez, thank you so much. Bob Ward, appreciate it. Still to come, what impact will Trooper Proctor have on Walsh's trial?
The moment he stepped foot into investigating Brian Walsh and the disappearance of his wife, he knew he was under federal investigation.
Coming soon to Court TV.
It's the biggest story that we're covering. He is the boogeyman. Lori Daybell.
She said, "I will have you destroyed."
She's got another murder trial coming up.
A social media sensation, now a suspected killer.
We will not stop fighting. We have no quit.
Sean Diddy Combs arrested on a federal indictment.
The high-stakes trials you don't want to miss. Coming soon. Only on Court TV.
Then 5051 says, oh, she's skating. Right?
Correct.
And what did you write after that?
My response was 0 chance she skated.
And then what did you write?
She's
0 chance she skates. She's right?
Correct.
You decided on the 29th of January, 17 hours into this investigation, you decided individually, Trooper Proctor, you're not only going to put it on the girl, you decided you're going to make sure this is cut and dry, and the way you're going to do it is to make sure that she's. That's what you were saying.
That's Alan Jackson, the attorney for Karen Reed, going after Trooper Michael Proctor during that trial. Retrial coming up in 2025. But that same trooper, Michael Proctor, lead investigator on Brian Walsh's case. Take a look at this. Some complaints from Walsh's defense. The investigation of Mr. Walsh was being conducted at or around the same time that Proctor, his supervisors, and other agents of the Commonwealth were investigating the aforementioned Reed case and making biased and unprofessional remarks and decisions. Now, I want you to take a look at Brian Walsh's attorney in court going after Trooper Michael Proctor.
What we're able to determine is that Trooper Proctor, who was the lead investigator on this case, the moment he stepped foot into investigating Brian Walsh and the disappearance of his wife, he knew he was under federal investigation. And so his bias, his motive, anything or his integrity is forefront for him. So with all those thoughts, when you're considering all of that, I don't know how it's not Rule 14. I don't know how we're not already in possession of this. And so otherwise I'd rest on the papers. And they talk about Beal, your argument. In Beal, I agree the prosecutor doesn't have a duty to go investigate our case, but they have it. So we're not asking them to go get something they don't have. And in footnote 4 in Beal, which isn't cited in their brief, it specifically says the government isn't able to simply put their head in the sand if there is something exculpatory. And documents that show that the lead investigator in a homicide case knew he was under federal investigation the moment he stepped foot in the case is certainly.
Isn't it even stronger? Well, I'm not making your argument, but wasn't he already under prosecution?
No, Your Honor. Do you mean Mr. Walsh or do you mean, no.
What's the timing of his federal indictment?
Do you mean do you mean Trooper Proctor or Mr. Walsh?
I thought you were talking about Mr. Walsh.
No, Mr. Walsh's state investigation. No, Trooper Proctor knew he was under federal investigation the moment he stepped foot.
I thought you were saying there was a bias against your client because he was under federal law.
No, it's Trooper Proctor.
That's an additional bias, by the way.
Right, but we're just focused on that part, that the moment he stepped into this investigation, and bear in mind, the Norfolk County District Attorney's Office, they control homicide investigations. They work with the state police with CPAC. So now the Norfolk County District Attorney's Office knew that Proctor was under federal investigation, specifically for how he investigates supervision, etc. He now is the case officer in this matter while his case is pending. So that's one of a myriad reasons why not only are these documents relevant, they could very well be exculpatory. And under Rule 14, it's not exculpatory, it's material and relevant. And so with respect to that, I would rest on the papers, Your Honor.
So Brian Walsh's defense looking to get some more information about Trooper Proctor, trying to get some of those records to use against him in this case. So that brings us to our next question in this investigation. What impact will Trooper Proctor have on Walsh's trial? Is this a problem for prosecutors? Joining me, Massachusetts trial attorney Wayne Dennison. All right, Wayne, what are your thoughts there? How does this play now? Because, I mean, the allegations in the Karen Reed case are very specific to that case, right? That, he's covering up for another cop, protecting a cop, framing someone else. But how does any problems in that case relate to his work in this case?
Well, the argument that we saw from defense attorney was simply that he was already under federal investigation relative to the Karen Reed case. And in lots of ways, Boston is a big city, but a very small town. And so you see the same players over and over again. You've got, I think, a very difficult defense in this case, and you've got to put somebody on trial. So I suspect we're going to see another trial in which Michael Proctor is going to be a centerpiece, although I'm sure that the prosecution will try to deflect that as much as possible.
So Well, how does that play in front of a jury, right? In Karen Reed, I get it. Like, I understood it. I could follow, I could connect the dots as to what their theory was. But Brian Walshe is, this case has nothing to do with police, has nothing to do with alleged corruption. It has nothing to do with a cover-up. This is, for lack of a better term, simple domestic violence type of case with people who are not connected to law enforcement at all. So is it a stretch by the defense? Is it a sign of desperation because they have nothing else?
Well, I don't know. I don't know if it's a stretch, but I can tell you this. If you don't have anything else, you're going to have to point to the empty chair. And Michael Proctor is going to be the empty chair in this case because the prosecution has already made it clear that they're not going to put him on. And what the defense will say is that this guy is a bad cop. And he was the lead prosecutor on this case. He was the lead investigator on this case. And this case is therefore dirty and impugned by the fact that the lead investigator is a bad cop.
Now, one of the big revelations for the defense in the Karen Reed case was getting Trooper Proctor's cell phone. Do you think they'll have an opportunity to get those records from his cell phone, whether it's text messages and other things?
Well, that part of the argument that you just saw was what materials does the prosecution already have in hand, largely from the Karen Reed case, that they should be turning over in the Walshe case. And that was the entire argument that you just saw in front of Judge Frenier, that was all about those various materials that we already know about. It has been some expectation that the prosecution is going to go out and try to make some inquiry into what, if anything, Proctor has that might point to some level of misconduct here.
Yeah.
But who knows how hard they're going to push that.
Wayne Dennison, great to see you. Thank you so much. Now, I don't know what Brian Walsh's defense will be, but if he claims that Anna just ran away, I don't think anyone's going to buy it. There's no proof of life anywhere. But even more so, there are 3 little boys without a mom. There's no way she would have just walked out and walked away from them. And there's no way you can sell that to a jury. That being said, without a body, jurors still may have some lingering questions. I'm Vinny Politan. We'll keep digging for the answers as the investigation continues.
Are you ready for Judge Freniette to come out? All right, so we're ready for the judge whenever she's ready. Oh, yeah.
Yep. You're working. No.
May I proceed, Your Honor?
Yes, please.
Thank you. The matter before the Court is Commonwealth versus Brian Walsh on Norfolk County docket 2382CR0091. Mr. Walsh is present, represented by Kelly Porges and Larry Tipton. Commonwealth is represented by Assistant District Attorneys Ann Yaz, Gregory Connor, Lauren McLaughlin, and Tracy Cusack. This is on for a hearing on a motion to dismiss.
Good morning, counsel. Please introduce yourself.
Good morning, Your Honor. Greg Connor for the Commonwealth.
Good morning, Your Honor. Laura McLaughlin for the Commonwealth.
Good morning, Your Honor. Tracy Cusack for the Commonwealth.
And Ms. Yaz is sitting behind us.
Not enough space for her?
Hopefully you only have to hear from three of us today, Your Honor.
All right. Well, I appreciate everyone being here, and I see that you have a new...
Yes, I'm working...
I heard about that the last time we were together, so I'm glad to see you.
Thank you, Your Honor.
Welcome to the defense.
Good morning, Your Honor. Good morning, everyone. Kelly Porges on behalf of Mr. Walsh.
Good morning.
Good morning, Your Honor. Larry Tipton for Mr. Walsh, and I would just ask, once again, renew my request to have his handcuffs removed so he can use a pen, and I did speak with the court officers.
And I spoke with the court officer this morning, and as I said to you in the last places we've been, I follow the rules as they direct me. And in this instance, I understand that the court officer is comfortable with that, so his cuffs will be removed. So we're here today on, I guess, to handle two matters that are on my radar, and I'm happy to handle anything else that you want to bring to my attention. But of principal concern to me today is the defendant's motion to dismiss and also a motion with regard to the, I'll call it the federal protective order. And I just want to address that specific to this case. I think that we were all on a call or all listening to the same hearing before Judge Krupp. I didn't feel the need to necessarily engage myself in those hearings and let it play out. As you know, I had sort of put a temporary hold for a hearing last Friday, which I ultimately decided we didn't need to do because of the events as they progress. But we can talk about that as well today and how that particular issue impacts this case, which may be very different than some of the other cases that were involved in the prior hearing. But I'll hear you on those two motions, and then again, anything else that you wish. So let me just tell you where I am with regard to my level of preparation so that you can respond accordingly. I have read all the days of the grand jury transcript. I have read, I'd probably say, 75% of all the documents that were presented to the grand jury. And that 75% is directed towards the issues that I thought would be important for today. So for instance, I didn't spend any time looking at grand jury records that related to airlines. I didn't spend any time looking at grand jury records that related to finances. Although you can make an argument that the argument isn't made with regard to what's contained in those records. So I read all relevant, what I thought were relevant grand jury exhibits. I've obviously read your motions. So as a preliminary matter, that's where I start. The defense's motion. I'll hear from the defense first.
Thank you, Judge. First thing I want to address is this, the interpretation of Riley. And we cite to Riley, and then the Commonwealth cites to Riley, and it appears that Commonwealth relies on Riley and their interpretation of Riley to say, since we, in their opinion, met the sufficiency of evidence as to premeditation and specific intent, now we can also prosecute on extreme atrocity and cruelty. Let me just first address Riley. That's not what Riley says. What we made clear in our memorandum is that Riley stands for the simple proposition that they clarified DePace. They basically said, just to be clear, DePace was talking about the face of an indictment under 265-1. And they said, now this case Riley presents a different matter. And so to be clear, you have to present sufficient evidence to the grand jury on first-degree murder, and they kind of left it at that. Then the opinion kind of wanders off and says something about, in footnote 8, that the Commonwealth tends to rely on, saying that if you present any theory of first-degree murder, you can then, it seems to be saying you can, at least that's what the Commonwealth says, you can then prosecute on any theory. That's not logical. If you just think about it for a moment, Judge, that would defy well-standing law. Moran, Walshe now, Humberto H., Handwright, the cases we cite, and 2 of the cases that they cite, Moran and Walshe, that make it clear that elements of the crime at issue, the grand jury has to hear sufficient evidence to make out the elements of the crime that is going to be indicted. And what does that mean for this case? What it means is that you have to, if you want to prosecute Mr. Walshe on a theory of extreme atrocity and cruelty, you have to give the grand jury at least sufficient evidence meeting the probable cause to arrest standard on what the elements of extreme atrocity and cruelty are. And what do those elements include? They include the 3 now Castillo factors, that the grand jury has to hear sufficient evidence of at least one, I would suggest at least one, if not all 3 of those factors. They heard nothing at all. And the Commonwealth in their memorandum does not even try to argue that they presented any evidence of those factors. And why is that? Why is it important to understand that what Riley says and what Riley doesn't say? Because if you just think about it for one moment, if a grand jury only heard sufficient evidence of third-pronged malice, an intent to do an act that a reasonable person with the facts known to the defendant at the time would have believed would have resulted in a plain and strong likelihood of death. And let's just say for this hypothetical that the grand jury also heard sufficient evidence of premeditation. Is it the Commonwealth's position that the indictment, whether it's issued with the language of 265-1, would allow a prosecution of premeditated murder? Of course it wouldn't, because the only malice element that grand jury heard was third-pronged malice that does not apply to premeditated murder.
Is that fair recitation or evaluation of the evidence that was presented, that they only heard third-pronged malice?
No, I'm not representing that, Judge. I'm trying to just distinguish and make clear.
All right, so let me just ask you, Attorney Tipton.
Yes.
It seems to me that this motion to dismiss is based on an argument of insufficient evidence. And the issue that you're raising now seems to me to be something that is relevant perhaps to a motion in limine with regard to what the Commonwealth can produce at trial. But your task today is to convince me that there was insufficient evidence of premeditation, right?
Well, that's right insofar as you've stated it, but I understand my task is also to argue that they did not provide sufficient information to establish.
Well, you agree with me, sir, that if they provided sufficient evidence of premeditation, the first-degree murder and malice, the first-degree murder indictment stands.
The first-degree murder insofar as it alleges premeditated murder.
Goes back to what I just said. Isn't this an issue that you're addressing with the court, an issue with regard to limitations on evidence if you're unsuccessful in this motion down the road?
If I understand the court, Judge, and I might not, so let me know if I'm not. But all I'm saying is, I think what is being confused here is the interpretation of how The statutory language of 265.1 encompasses all three theories of first-degree murder. It encompasses second-degree murder, and it encompasses manslaughter, unless it's otherwise limited by the grand jury in the language. And that's pretty clear law, at least since 2009. What I'm here for is to say that so much of that indictment that is the Commonwealth believes alleges first-degree murder based on extreme atrocity and cruelty, it does not, because the grand jury did not hear sufficient evidence of first-degree murder. The same with felony murder.
All right. I understand the argument. I will take a closer look at Riley, maybe not for purposes, maybe for purposes of resolving this dispute, but certainly for purposes of future aspects of the case. But you need to convince me, I think, the Commonwealth, whether they would like to proceed on a theory of cruel and atrocious or not, it's clear that their fastball, so to speak, in this case, is premeditation. So convince me that there's not enough in the grand jury transcript, and not only in the transcript, what's before the grand jury is all of this, and this is only part of this, all of the exhibits that were presented to the grand jury is before them. And one of the things that I noticed when I was reading through your argument is you almost exclusively focus on the testimony that was provided to the grand jury. And I don't want to say you ignore the other stuff, but it's not discussed. And it is before the grand jury for them to consider. So convince me that there's not enough there.
Well, there's nothing in the grand jury exhibits that have any statement, any conduct that can be attributed to Mr. Walsh that he planned a murder, that he planned to harm Ms. Walsh. Nothing at all. All of the conduct of the exhibits that are contained in the exhibits are conduct that occurred after something happened. Whatever it was happened, after something happened.
What do you mean by that?
Well, because the clear reading of, first, the searches don't indicate that he's planning or anything other than he's talking, as the grand jury witness testified to, asked by the prosecutors, how do you characterize those searches? They're searches about how to clean up. There's not one search, as alarming as those searches can be interpreted. There's not one search that talks about planning to kill, intending to kill, or anything of the sort. There is not one exhibit produced to the grand jury that contains any statement, any plan, anything by Mr. Walsh about wanting to kill or harm or injure Anna Walsh.
As I understand the Commonwealth's argument, with regard to premeditation, their argument would be, from their opposition, that it's reasonable for a jury to infer that, or credit the defendant's statement that Anna left the house at 6:35 in the afternoon, in the morning, excuse me, that it would be reasonable for them to credit that the 6-year-old son saw his mother that morning, in the early morning. It would be reasonable for them to infer then that those incriminating searches between 4:53 a.m. and 6:35 a.m. happened before she was murdered, and that's supported by a 3-hour break in the searches from 6:35 until 9:35 a.m. There is significant motive evidence that was presented to the grand jury about $2.7 million in life insurance, about knowledge that Mr. Walsh knew that his wife was having an affair, probably as early as December 25th, 2022. And there was his motive evidence with regard to the conundrum of the federal prosecution and his pending sentence. That's all before the jury. As I understand their argument, it is that those searches that are done, and there's 8 of them done before 6:35 in the morning, are prior to. And even though it's reasonable to say that those searches relate to what you do once you have a dead body, that it's not inconsistent with the fact that he may not have yet killed her at the time that he did those searches. Those are the reasonable inferences they're saying that a grand jury could have found. Why isn't that within the bounds given the evidence that was before the grand jury?
First, the Commonwealth says, on the one hand, based on the statement of the defendant that, and of the young child, that he saw his mother. And then they go on to say, but the defendant was coaching him. And then at the grand jury, they go through an enormous amount of effort to dispute whether the child actually saw her, as they put on witnesses talking about everything from how well he understands English, the young child, what he does, what he doesn't understand, that he couldn't have created the searches. But they go on to try to dispute that what the child said is not accurate, and it's the result of coaching by the defendant. That's what the Commonwealth presented. We weren't there, but that's what they presented. Let me talk about the insurance. The court used the word motive. It's possible motive evidence, but motive evidence is not premeditation, and motive evidence is not malice. And there is nothing untoward about life insurance policies named in anybody's name, and there were still life insurance policies presented to the grand jury that still had Ms. Walsh as the beneficiary. So now we look at that quality of evidence. It may be some evidence of motive, but it is not evidence of premeditation. It is not evidence of malice, according to the case law. And there's nothing in
but the evidence of malice that they're going to rely on that was before the grand jury is certainly contained in those searches.
If the searches happened before.
That's their theory.
That is their theory. But
one of their theories, anyway.
But their evidence presented to the grand jury doesn't establish that, and it requires the grand jury to speculate and pile inference on inference and say, well, maybe it could have, I don't know what the grand jury was thinking.
All they have to believe is Mr. Walsh's own statement that she left at 6:30, right? And those searches.
But I think what the court is saying is the grand jury heard sufficient evidence to establish that somehow that contrary to what the Commonwealth presented to the evidence, the grand jury can still ignore what the Commonwealth presented, and that is they disputed that the child saw his mother at 6:30 in the morning. So you can't just throw, forgive me, but you can't just throw things against the wall and see what sticks, then walk away and say the grand jury heard sufficient evidence. And because that is the probable cause to arrest standard.
They don't need Thomas Walsh's, they don't need the minor's statement to establish probable cause. They can go at it alone with Mr. Walsh's statement, she left at 6:30, and the fact that those 6 searches are done before then. Isn't that sufficient? Counsel, we're talking about probable cause.
Judge, but what?
I'm not talking about proof beyond a reasonable doubt.
No, I understand that. I'm talking about probable cause to arrest and reasonable inferences on trustworthy evidence. What did the Commonwealth do in front of the grand jury? They tried to demonstrate that Mr. Walsh lied about Anna Walsh leaving at 6:30. The Commonwealth spent more than a day putting on evidence that She didn't leave at 6:30. She never left. So what he said was a lie. And that's the quality of the evidence that was presented to the grand jury. So if now the government wants to stand up and say, well, we want to have it both ways. We called him a liar in front of the grand jury, and we don't want the grand jury to believe that she left at 6:30, but we're going to rely on that very same evidence to construct this argument that, oh, as they say on, I forget what page it is, I have it, but they say that in a cryptic one sentence, maybe those searches happened before. And that's all they do.
All right, what's the argument? Let's change the playing field and say the argument is that, because they could pursue alternate theories, that she was murdered prior to the searches. So your argument with regard to lack of any probable cause before the jury is stronger, right?
I think so, yes.
All right. Anything else you want to ask me or you want to tell me?
About premeditation?
Yes.
We shouldn't discard the fact that premeditation requires, I understand there's a lot to do about the time element, and I'm not even going to recite all that case law, but it does, the case law also makes clear, and I cited to the model instructions for homicide on premeditation, that it's not just that someone says, okay, I'm going to kill somebody. There has to be cool reflection, there has to be a thought, and it has to be followed by action. They have no evidence of that. If the evidence is that now they want to construct an alternative argument that, okay, even though we wanted to convince the jury that Mr. Walsh was lying about 6:30, Anna Walsh leaving at 6:30, and even though we want to try to convince the grand jury that he coached his son and his son never saw Anna Walsh, we will nonetheless use that as sufficient evidence to get the indictment based on premeditation. That is not due process. And that's exactly what they did at the grand jury. They disputed the evidence. They did not endorse it when it came to what time she left and if the son ever in fact saw her. And now they want to use it. If they try to use it, they want to use it to say, therefore, the searches happened before the death. And the grand jury is entitled to do that. When in fact, the only evidence they presented to the grand jury was, you can't believe she left at 6:30, and you can't believe that the son saw her.
So the two of you are going in different directions on the significance of the destruction of evidence. That is, the Commonwealth cites to, and I will candidly acknowledge I haven't looked at the different cases that you've cited. I certainly will before I make any decision on this case. But the Commonwealth cites to the defense's argument that is sort of that destruction of, under the law, the destruction of evidence is not relevant to the issue of premeditation. And the Commonwealth cites me to, I'm going to butcher the last of this, I'll spell it so I don't butcher it, Dagenis, Dene, a 2002 case for the proposition that evidence of destruction of evidence is highly probative on the issue of premeditation.
Well, I think what that, I'm sorry, I don't want to interrupt.
Go ahead. That was the end of it.
Okay. And I too don't want to butcher the case name.
You can call it just D.
We'll call it D. Look, all that case said was, and the Commonwealth uses it in their memo, all it says is there's no blanket rule.
Prohibition against it.
That's right. But then you have to look at all the other cases that talk about that, and all the other cases, Blakey and all the other cases that we cite, say, well, it doesn't have any bearing, destruction of evidence doesn't have any bearing on premeditation if it happened before the blow. That's the phrase used in Blakey, before the blow was struck. That is bedrock case law. That's what they're talking about. So now, getting to your point, Judge, what is the case that they cite and is Nadworny? And I think that Nadworny talks about, consciousness of guilt evidence that may be used, may also be used to demonstrate, let's say, intent. And it goes hand in hand because there's a difference between the analysis of premeditation and intent. But what Nadworny, a case way back in the 70s, says is that on those facts, you could consider the condition of the body found in the trunk of the defendant's car that had been in the trunk for 4 months and show decomposition, show that it was specifically wrapped up like a funeral director may do it because his father worked at a funeral director. And they go on to elicit all those facts of how that type of thinking can be impugned to that defendant. You don't have anything like that here in this case. And so the grand jury didn't hear anything of the sort like that. And Blakey says, as well as any number of cases, that consciousness of guilt should not be used to try to prove malice or premeditation if you can't demonstrate that the so-called consciousness of guilt evidence, and I will say for purposes of this motion, it's probably likely that at trial, those searches would be considered consciousness of guilt if the Commonwealth can demonstrate sufficiently prior to introducing them that they were in fact created by Mr. Walsh and no other person, that they could be considered consciousness of guilt, but that's the limitation. And the case law that they cite and that we cite go on and talk about the errors that are asserted in appellate review where a defendant argues that you used consciousness of guilt to influence the jury on intent and premeditation. And what the analysis shows in many of those cases is, well, where the jury got a complete instruction on consciousness of guilt and premeditation and all the variations of malice, and many times the decisions are made by a substantial miscarriage of justice. But the point is, they're saying in those cases, we think the jury understood that you can't use that evidence other than consciousness of guilt. So in this case, you might have consciousness of guilt evidence, but that is not evidence of premeditation on these facts. You might have consciousness of guilt evidence, but it's not evidence of intent, and it's not evidence that establishes any of the 3 prongs of malice. And that's what we argue throughout our brief. I think I heard Your Honor refer to affair, the knowledge of the affair. Let me just talk about that for just a moment. And then I have to circle back and not repeat what I said, but I want to talk about inferences and how they apply to the arguments that the Commonwealth makes in their memorandum. First, I know the government wants, and they've said it to the public, but they're just wrong. Mr. Walsh did not know about an affair, period. What AK, and I'll just use the initials that I did in the memo, what AK told the grand jury was that Anna Walsh had talked about telling Mr. Walsh she had a crush on someone. There was no testimony by AK that Anna Walsh discussed with her that Mr. Walsh knew about the affair that was ongoing.
I don't think that's correct, counsel.
Okay.
Let me tell you what I have in mind from reading. I just need to find the right piece of paper, but I will. AK testified that the defendant told Anna that his mother had told him that Anna was going to leave him for a guy in D.C. and take the kids, and that he believed that. That was her testimony.
I'm trying to think of that specific, I recall that specific testimony, but I don't think I thought it said that, well,
59 to 60 of the transcript.
all right. Can you pull that up?
Your Honor, do you have a date from that grand jury?
March 8th, 2023.
Thank you.
The defendant told the police in his January 4th interview that he had access to Anna's iMessenger on his phone and some access to her Instagram. Those are the two ways that Anna communicated with WF for his testimony. Also before the grand jury was that he, the defendant, searched WF's name 6 times on December 25th, 2022. That there were 20-something, 21, 25 searches between the 26th and January 1st on his Instagram account. They don't know where they were, too. Also before them were the messages between WF and Anna, which leave little doubt that there was an affair going on.
When the, if I may inquire,
So I've got to assess the evidence that was before the grand jury in its entirety. And that was the entirety of the evidence that was before them with regard to whether there was an affair going on and whether he knew about it, right?
Well, that's not the entirety. I'm sorry, Judge. I don't.
Well, that's some of it.
That's some of it. It's not the entirety, though, because the entirety also includes the testimony of the other testimony of AK and the other testimony of WF. And that testimony from WF was specific that him and WF and Anna were talking about their affair and that she wanted to tell Mr. Walshe about it, that she would, quote, be devastated if he learned about it. And then there's this conversation about his mother hiring the psychic and that's where that came from, hiring a psychic that told her, the mother, that Anna Walshe may leave the defendant for someone in D.C. And then WF is asked specifically by the government, was there any conversation about Mr. Walshe knowing, I'm going to paraphrase, knowing about the affair? No. Was there any conversation about whether she had told him about the affair? She wanted to tell him about the affair at some point.
Does evidence go to the issue of whether or not Anna knew that Brian knew about the affair, not whether Brian knew about the affair?
Well, when the court recites the fact that if we assume for purposes of this motion that Mr. Walshe is the one that reached out and tried to search for WF, how does that show, how does that demonstrate reasonable and trustworthy and reliable facts, articulable facts, that he knew about, quote, an affair, as opposed to the simple truth that was presented to the grand jury that she had a crush on?
Well, let's put aside the searches on the searches on the December 25th and put aside the 21 other searches between those dates and just focus on his admission to the police on the 4th of his access to her Instagram and to her iMessenger and WF's exhibits of the messages between Anna and himself. As I said, there's little doubt based on what's in there. You know what's in there, that there was an affair going on, right?
And you're referencing the messaging between Anna and WF.
Correct, which the defendant told the police on the 4th of January that he had access to that during his interview. And that was before the grand jury too.
He may have he in fact told the police that, yes, he had access to it. He never told the police that he read those text messages. He saw those text messages.
Isn't that a reasonable inference?
Why would it be? Why would it be a reasonable inference that jumps from the fact that someone may in fact be able to access messaging, but there is that he has access to it, but that in fact he did? Why is that?
I don't think that's his language on 1-4, but that he had access to it. I'll go back and listen to it again, but my memory of it was that they were coming up on his phone.
Okay.
But I'll go back and refresh that. But what did you want to? So this idea, this notion that that there's no evidence supporting the fact that he knew of the affair, just doesn't seem to me to be a fair assessment of the evidence that was before the grand jury.
And what we're arguing, Judge, that it can only be a fair assessment based on reasonable and articulable facts of trustworthy information. There is no trustworthy information. There's no information at all that Mr. Walshe read Anna Walsh's messaging between herself and WF.
Does somebody have the January 4th interview, page 30, lines 8 to 22? I have it here. I just don't know what exactly it is. Oh, maybe I do. Anyway, I'll go back and look at it. That's the area where, that is the location where he discusses in his interview on January 4th, his access. You may be right, it's access and not that he actually looked at it.
And I'll take a look and see if I'm wrong.
All right.
Could I just go back to pages 60 and 61? And
yes, I have it right here.
So I thought the court had recited in saying that there was testimony that Brian believed.
Anna believed, Brian believed. So I'm on 60, line 11. Diana was convinced that she went to a psychic and that due to that, she was convinced that Anna was going to leave Brian for some guy in DC and take the kids, and that she believed Brian believed that.
Well, but maybe I misheard the court. I thought you said that there was direct testimony that Brian had represented that there was a statement attributed to Brian Walshe.
No. He consistently, throughout his interviews, as I know them, with the police, averred that he wasn't having an affair, and he didn't believe she was either.
Okay, so turning back to that now, Judge, line 11 at page 60. Anna can believe what she wants to believe. There is no factual basis presented to the grand jury that Brian Walshe did, in fact, believe that. In fact, the evidence presented...
Believe what?
That she was having an affair. In fact, there's testimony at the grand jury that this psychic investigation was revealed by Brian to Anna Walshe. So how is it then that when people are sharing information and nothing happens at that time, nothing untoward at all happens at that time, that the government can then move on and pile another inference on top of that inference and say, therefore, Brian Walshe believed there was an affair, and therefore Brian Walshe acted on that belief, and therefore there's evidence of premeditation as opposed to motive or whatever. But how can a grand jury be permitted to pile inference on inference when that's what the government is at? If in fact that's what the government intends, that's what occurred. There is no trustworthy, reliable information that Brian Walshe believed or knew about an affair. And when you consider the testimony of WF at the grand jury, and the testimony in conjunction with AK, did she ever say he was jealous?
Counsel, let's circle back to those
Right.
December 25th, 2022, the 6 searches with regard to William Fasto on that day. So there are 6 searches that are done on a device that's attributed to Mr. Walshe for Mr. Fasto's name on December 25th.
Yes.
I think it's just randomly searching the guy's name on December 25th, the day that his wife is supposed to be coming home and missed her flight.
Well, he's trying to find out where she is because she's late, and she has to leave on the 25th, and she misses the flight, and she has to drive up.
And she thinks of William Fasto, or he thinks of William Fasto.
Well, he's also reaching out to others, I believe.
He didn't, as far as I know, the only information before the court from the materials that were in the grand jury is he searches William Fasto's name 6 times that day.
Okay, but William, she's already, if you believe what was presented to the grand jury, and that's the constraint we're under right now.
Sure.
She, according to AK, she told Mr. Walshe she had a crush on WF. So why wouldn't he, if your spouse says, I have a crush on this person, the other spouse is not allowed just to say, I want to learn about what that other person is.
When does, and this is up for grabs for either side, I have a question with regard to the evidence that was before the grand jury. I just got to find that. So much paper.
You can't be an environmentalist, I'm afraid, and be a lawyer.
Not a lawyer that's this old anyway. One of the exhibits to Mr. Dozier's grand jury is a series of voicemails left by Diana. And I've listened to those files. My question for the more technically enabled people is, was it before the grand jury that file number 046, or any of the files that Mr. Dozier provided, time-stamped in any way? Does anyone know that from your review of the evidence?
Off the top of my head, standing here,
All right, so the Commonwealth, I know there's a lot of you over there, but if somebody can answer that question when you get up to argue, if you can, I'd appreciate an answer to that.
But talking about, and you're talking about the investigator when you.
Yes,
Okay.
and it something you just said triggered that memory of sort of a open question in my mind, was whether or not the grand jurors had before them, other than by context of what's being said in those messages, the timestamp for the days those messages were left.
And we can get the answer to that question, but the testimony of Mr. Dozier under oath was that there was no testimony that he got in. That's the other interesting thing. He never got a name.
Well, he never gave the name. He had a name. They had a person of interest. It was WF, but he never provided that name to them. That was something that's how I recall his testimony.
And what I was about to say was he never testified, and he was asked, or I guess asked in substance, no one like Brian Walshe gave him a name. And in fact, the government kept asking that witness, when did you ever talk to Brian Walshe? Yes, we did have some conversations. When did that occur? If my memory, I'm paraphrasing, if my memory serves me, it was sometime after January 1st. January 1st. So I think that's another piece of trustworthy and reliable information that someone could make an inference that at some point Mr. Walshe became aware of an investigation that his mother instigated, but there was no evidence that that investigation was informed by Mr. Walshe, and Mr. Walshe didn't have a reason to get on the phone and say, hey, apparently, to check out this WF guy. So that's why we say in our memo that when the government begins to spin out what it believes are reasonable inferences, they are not grounded in articulable and trustworthy and reliable facts. They are the ruminations of the Commonwealth trying to justify that what they presented to the grand jury is sufficient in making out the elements of the charge, even though, as I return briefly, they don't even attempt to make out the elements of extreme atrocity and cruelty when it comes to what was presented to the grand jury. Another final example of this, and I know the court didn't reference it a moment ago, but it's this articulated argument by the government that somehow, and they go on for almost a full page talking about the facade that Mr. Walshe created by making it look like to everybody that it was just a happy family, and that was his plan to present to GM this presentation that it was just a happy family. You know, Judge, what the grand jury, and that's the government's inference. Okay, what's the articulable and reasonable facts, trustworthy facts that establish that? Nothing at all. It's an inference that is created out of whole cloth, and it's used by the Commonwealth in their memo to suggest, see, that was his planning stage. That's what he was planning. Who invited GM?
Anna did. On December 29th during the phone call.
And here's this long visit of hours where there's nothing but happiness and cooking and eating and a little bit of drinking champagne, and then at 1:30 he leaves. We recite all of that evidence because it is the trustworthy and reliable evidence that the grand jury heard and contradicts not the other evidence that they heard, it contradicts the inferences that the government is trying to make. Did it get across the finish line here on the grand jury presentment? And
well, I credit what you're saying, that this argument that he somehow in some planning phase called Mr. Mutlu and invited him over for, I probably mispronounced that as well, but invited him over for dinner is contradicted by the evidence that Jim himself presented, and which he clearly said he was invited by Anna on the 29th. It's contradicted by the text messages between Anna and Mr. Fasto, in which she discusses inviting him over. So I credit that the evidence wasn't that that was a planning thing as far as the evidence that I can see before the grand jury. But also, it's clear that there was sufficient evidence before the grand jury that this marriage was in distress over the issues relating to his then pending federal sentence and the implications of that on their life and where the children lived. It was clear that AK was seeing something different than she had ever seen before in her friend, in her demeanor. She mentions that in her, which a reasonable inference could be based on the context of that, which was she was talking about her marriage and the failings of her marriage, that their marriage was under stress. So while I credit you that this notion that he planned this by ordering or by inviting Jem over, there doesn't seem to be any evidence before the grand jury that I can see. He'll argue otherwise, perhaps.
And let me respond to some of that, though, Judge, some of the themes of what you just said. Once again, I'm going to very quickly refer to AK's testimony. Yes, friends with Anna Walshe, recited conversations with Anna Walshe, was asked specifically, did she ever talk about divorce? No. No. What did she talk about? She talked about the frustration of not having the 3 kids in D.C. and the time it was taking. And who was Anna Walshe angry with? She was upset with Brian, but she was angry at his lawyer because she thought the lawyer was the one setting up this idea that the kids had to, the 3 children had to stay in Cohasset. That wasn't Brian's doing. The government tries to argue that, but that's not what the grand jury heard. Also, AK testifies initially.
But what the grand jury heard is she was angry with him because she had learned that it was not the FBI, but rather Brian himself that was delaying his sentence. That's the sentence, delaying the trial or the resolution of that case.
And she goes on to, I understand, she goes on to testify that Anna Walshe then was talking about Mr. Walshe, Brian, had to take responsibility and that they needed to work through this. And that's exactly what they were doing. To suggest that stressors, serious stressors that have been going on for some time, somehow transform into motive to kill, malice, or premeditation is once again an inference that is not supported. It is, somebody can dream up the inference like the government is doing here, but it doesn't rest on the facts, and it doesn't rest on the entirety of the testimony of of AK. The same thing with the WF testimony. You know, if what the grand jury heard was, yes, there was conversations, but there was never the only conversation that he recalled where divorce was mentioned was in terms of, quote, protecting assets. And I will just, that's it. That's all he recalled. And when the assets may have been the life insurance. It might have been the value of the condominium, $1.3 million. It might have been the other properties they owned. They were renting the Cohasset property, but maybe the other properties. But here is WF being asked a myriad of questions about, well, didn't she talk about this? Didn't she talk about that? No. She always, quote, I'm not quoting, paraphrasing. WF said that what Anna Walshe described Brian was basically this wonderful man. That doesn't sound like, and it can't be used to now construct some argument that whatever stressors were going on in the family then can be used to establish premeditation or malice in any of its forms. It is, as we say, it is piling inference on inference, and doing so is violation of due process in Article 12 because the grand jury wasn't presented that type of evidence. It is the inferences that are being constructed by the Commonwealth that aren't grounded in articulable facts, plain and simple. The other thing is about the money. They'd already started paying the money back. This idea constructed out of the whole cloth that somehow one of his motives was to murder his wife so he gets access to monies so he can pay $450,000 that they'd already started paying for, and they had all these properties, just defies logic.
What was the evidence before the grand jury that they, since you mentioned it, that he had paid back anything?
I think that I know it's in the grand jury somewhere, Judge, because
Where?
I will find it. I'll give you a particular citation.
Anyone?
Mr. Walsh made statements that one of the 4 days that he was interviewed by the police, he'd explained, I believe his attorney was present when they both represented that part of the money had already been paid back. And Tracy Minor indicated to the detective that they were trying to pay back as much money as possible prior to the sentencing.
Well, I knew that part. I
And they
appreciate
represented
that.
that money had been paid back. A number had never been given for the amount.
It wasn't in the grand jury, it was in the exhibit.
And is there anything in the exhibits that were before well, that's in the grand jury. Exhibit.
I understand, but I was misleading when I said it was in the grand jury.
No, I think that's the proper statement. Before the grand jury, it was an exhibit to them. Was the federal docket that has been presented to me, and I don't remember in connection with what at this point, because I have so many motions that I'm considering, but you know that somewhere in my travels, I've come across the federal docket to his federal case that was attached to something. Mm-hmm. Was that ever before the grand jury? I don't think so.
No, Your Honor. Right. There was reference to the federal case. Yes.
There's reference to the federal case. I was just wondering whether there's any evidence of payment in that docket, because if there was evidence of payment in the docket, then it would be fair to say that they had evidence before them. Often, in my experience, when restitution is paid, it may not have happened here because the sentence doesn't happen until 2024. But that would have been certainly something that would have been noted. And they did get darn close, it looks like, from my recollection of my review of that docket to a sentencing. But then I don't know what happened, but they retreated.
So if the grand jury
so they do have evidence in his statements that some restitution was paid.
And they did not hear any evidence that there was some conflict about, or some argument about the amount of money that had to be paid back. There's nothing like that presented to the grand jury. There were the stresses revolved around primarily the 3 children in the DC. And once again, AK testified about the plans that both Brian and Anna Walsh were trying to make to move the 3 kids up to DC. So what you have is testimony of stresses in a family grounded in what we'd all believe would be true. 3 young children living in one place, mother living in another, and they're trying to work this out, and it's taking longer than expected. How does that become a reasonable, articulable, and trustworthy fact to build a premise that stress led to premeditated murder or malice in any of its forms? It's pure conjecture, it's speculation, and it can't be the basis for this indictment. I don't want to keep going on here. I would like just to make clear something here before I sit down. And you can shut me down, Judge. I know you will if you want to, but it's this Riley thing. And let me just say briefly, I would be happy.
I won't shut you down because I'm not sure, I'm still not convinced that it's relevant to the decision I need to make on this motion, but okay, it's certainly going to be relevant later, so that the earlier I get educated, the better.
So let me try to make, the argument that it is relevant.
Okay.
Because we do argue it. What we're saying basically is that the grand jury has to hear the elements of the offenses that are encapsulated in 265.1 statutory language. It's not, there's 2 separate bodies of law. 265.1, that covers all the theories, but that is a procedural issue. It's a little substantive, but it's procedural. Over here, we have all the case law, Moran, Walshe, and I believe, the way I interpret Riley, to say this: you have to present the elements And for some reason, the way the justice wrote that opinion in Riley was, we want to clarify what we left open in DePace. He doesn't talk about Moran or anything. And what I think he's clarifying is, let's just be clear. In DePace, we talked about 265-1 because the challenge was on the face of the indictment. In Riley, we're talking about something else. We're talking about what the grand jury heard. And so under Moran, if the grand jury does not hear sufficient evidence of the elements of a particular theory of murder, then the indictment, as we're asking, that so much of the indictment that can be read to include, in this case, extreme atrocity, and they didn't argue felony murder, so I'm not going to waste the court's time on that, but extreme atrocity, you can't try him on extreme atrocity because the indictment doesn't include it.
See, we're ending at the same place. To me, you're seeking to limit the Commonwealth with regard to the theories it may pursue at trial based on a failing in your perceived failing of proof in the grand jury. It seems to me that's not a dismissal of the indictment for first-degree murder. It's a motion in limine to say that the Commonwealth can't have that evidence at trial. Even if I credited your worldview with regard to that case law, that alone wouldn't result in the dismissal of the indictment because of the evidence, if I credited it, of premeditation, right? That's why I see this slightly differently than you do.
Well, and I would agree with you, Judge. If you found sufficient evidence to the grand jury of premeditation and the type of malice that only applies to premeditated murder, if you find that, I agree so much of the indictment that charges first-degree premeditated murder stands. But it's due process that requires this court to consider whether that indictment that was issued under the language of 265-1 encompasses extreme atrocity and cruelty, and for that matter, felony murder. And why? Because we have to be able to prepare our defense, and we have to know what the Commonwealth is going to charge, because that's the other part of this due process argument. We have to be prepared to challenge the extreme proof of extreme atrocity and cruelty, and they can't present it because the
regardless of what, if my ruling ends up that the murder charge isn't dismissed, you have plenty of time. You don't have to wait on your motions in limine. You will have plenty of time to brief and address that issue between now and October. I mean, it's plain to anybody in this courtroom that knows the evidence in this case that whatever the Commonwealth's evidence is with regard to cruel and atrocious behavior, certainly isn't their lead argument. It's not great.
Well,
it'll be even if I allowed it. Frankly, this is where I go off script, and it's never good. Even if I allowed your motion or I denied your motion and said, "Oh no, they can go forward on both theories," as a strategic matter, they got to start thinking, "Are we shooting ourselves in the foot by doing so?" Because from what I've seen, it's pretty thin.
I appreciate that comment, Judge. I understand you're not making a ruling, but I appreciate the comment. But I'm not going to.
But I get it. You have to get ready for trial in both theories.
And I'm going to infuriate Assistant District Attorney Cusick when I say this. I'm going to stop beating this dead horse. You and I, and Attorney Porges on behalf of Walshe, I don't think I'm making myself clear about the differences between what you're suggesting, a motion in limine to kick out a theory of first-degree murder, and what we're asking for the court to do.
You're asking me, I know what you're saying, you're asking me to dismiss it in so much as it charges cruel and atrocious.
Yes.
I understand what you're asking for. I'm not even sure, well, I'll look at your cases. I'm not even sure I've seen that ever done. It's an interesting concept, and I'll give some more thought to that if I get there. Maybe the Commonwealth will make our job easier.
It looks like they've made our job easier for felony murder. They didn't even brief it.
Right. Well, we got to start. I mean, October, tick-tock, it's coming. So figure out what your theories are going to be, and let's argue about the things that really matter, right?
Well, these really matter to us.
I
understand.
I don't take any of this lightly. And when I say, let's talk about the things that matter, if it is the case that the Commonwealth's not going to really pursue cruel and atrocious, then we're just wasting our time, right?
I have a brief moment to ask a question.
Certainly.
I think that's all we have.
And by the way, in fairness to both sides, I only know what I know. That is, I know all the stuff that I've read. I know everything that went to the grand jury. That was March 2023. What I don't know is all the stuff that's happened since March of 2023, and whether that has any bearing on the Commonwealth's ability to pursue a cruel and atrocious. I don't know. I only know what I know.
Your Honor, I'm going to sit down after I say this final sentence. That makes my argument. If they develop evidence post-grand jury of extreme atrocity and cruelty, they can't just decide, oh, now we have evidence of it, we can try them on that. They have to go to the grand jury and get an indictment. And I think that encapsulates what we're talking about here.
I understand the argument.
Thank you, Judge.
Thank you.
Good morning, Your Honor.
Good morning.
Your Honor, the Commonwealth disagrees with Mr. Tipton's interpretation of the Riley case. Obviously, the court has it and will interpret it as the court deems appropriate. But I would suggest here that the court should not eliminate any theory of first-degree murder, because here the grand jury did have probable cause to find that the defendant committed a premeditated murder with the intent to kill. A few housekeeping matters. The Commonwealth agreed. We're not saying that we thought Mr. Walshe, there was evidence before the grand jury that Mr. Walshe invited the New Year's Eve guest. That was Anna who invited him. The Commonwealth's argument is, with the guests being there, Mr. Walshe used the guest's presence to create a facade of a jovial, happy couple having a New Year's Eve celebration. And I suggest that that is also borne out by the fact that when Mr. Walshe eventually got in touch with the New Year's Eve guest, I think it was on January 4th, he was asked by the New Year's Eve guest, GM, well, did you argue? And Mr. Walsh's response was, you saw us. Did it look like we argued? So I would suggest that that certainly supports that dinner was used as a charade. Your Honor, the defendant had serious financial, legal, and marital problems in December of 2022. There was ample evidence that he was aware of Anna Walsh's relationship with a man in D.C. He's certainly doing those searches on Christmas Day. That's the day Anna had said she had to work. Mr. Walshe said that in one of the interviews with the police, that she wasn't home on Christmas Eve because she had to work. And there was certainly, she did show up late. The flight had been canceled. She did drive up, and that's the night he begins searching those WF's name online. Then later on December 27th, he's doing a search about divorce and states to get divorced in, and the results of that search shows that Massachusetts is not a favorable state for divorce. And then the mother hires the private investigator in D.C. Now the mother says she got the name from Mr. Walshe, that he told her not to do it, but I would suggest here he gives her the name of a private investigator. She hires the private investigator to investigate whether Anna is engaged in activities that are not appropriate for a married woman. And certainly I understand the court's question about the timing of those voicemails. I don't know off the top of my head the voicemails from the mother to the investigator firm, but we will look into that and see if there is anything.
The one that I'm most interested in is, well, I'm interested in whether there's a timestamp on any of them, but the one that I'm most interested in is file 046. And in that message, she indicates, my son says, could you please check WF? Because during that period, he was in Idaho, and he just wants to see how often they saw each other. That's the one that I want to know, that whether the evidence was before the grand jury as to what the time frame of that was.
Certainly, Your Honor. We will examine the exhibits, and we'll let the court know, and we'll let counsel know, obviously, what we decipher, whether the timestamp is indeed in front of them or whether it was not. Your Honor, here, the grand jury also had information from the testimony of AK about her conversation with Anna on December 29th, I believe. They went out to dinner, and she describes Anna as just being beside herself. Anna described a huge fight with the defendant over Christmas, had given him an ultimatum about the children coming to D.C. to live with her. She had found out that the defendant, and she does mention the lawyer also, but essentially that the defendant had engineered the children remaining in Cohasset with him because it was perceived that that would help him avoid an incarcerated sentence on his federal case. Certainly there's discussion of that during the interview with the one where the lawyer was present at, and he makes a remark about which one could infer means essentially, well, if Anna's not around, that's off the table of me going to jail. But certainly recent news to the defendant and to Anna as related through various conversations that suddenly the topic of him going to jail had arisen, and that according to AK, Anna had said he should just do whatever is necessary to resolve this, even if it involves an incarcerated sentence. So I suggest that is another, we could characterize it as a stressor, but it's also another reason why if Anna's not around, if Anna is deceased or disappeared, the defendant would suddenly be a single parent, would have the children's sole caretaking for these 3 small children. He would potentially avoid that committed sentence, which he was very motivated, one could infer from the materials before the grand jury in avoiding. He would inherit millions of dollars in life insurance proceeds from Anna. Again, those searches also include some searches for luxury items. One could infer that he's planning to how he might spend those proceeds. And he would also,
but those searches, I don't think that rings true, because those searches with regard to in terms of premeditation anyway, the searches with regard to the watch are later.
I agree with that, Your Honor. I just suggest that.
So how does that relate to premeditation?
Your Honor, I suggest it relates to the concept of having money, which was certainly a stressor, that the defendant needed money to pay that restitution. I know at some point, I believe it was in the interview with the lawyer, forgive me if I'm mistaken, but I think it was he owed $450,000 in federal restitution. And I suggest here, the fact that he is looking at luxury goods suggests that this is, again, expecting to inherit money. Some of the searches are for cleaning up crime scenes. Specifically, I suggest that shows that the defendant's awareness that this was indeed a crime and not some sort of accidental person dying in a home. Your Honor, I suggest also that the defendant's behavior before that time, approximately 6:30 in the morning on January 1st, his behavior before that time when he says Anna left the house shows that he was planning and premeditating and had the intent to kill her. She arrived at the home on December 30th from D.C. She was not scheduled to go back until January 3rd. So certainly there's a block of time where no one at her work would be looking for her. He planned to appear happy and jovial with the New Year's Eve guest. And again, when he spoke to the guest next, and the guest said, "Were you arguing?" "No, you saw us. Did it look like we were arguing?" He also told the guest that his phone was misplaced. I suggest that was also part of the planning, creating a window of time when he didn't have the phone, that it would be an explanation as to why not responding to any text messages. Certainly, how do we know this was planned? Forensic exam shows that phone was actually in motion, being unlocked and plugged into a power source when it was alleged to have been missing. So I would suggest that's another thing that would go towards planning. And the defendant, planned for
The fact that he shut off his phone, or he put his phone, the phone that's missing, let's even make the most adverse inference to the defendant. That all happens after the Commonwealth believes that he's killed Anna, right?
Your Honor, he tells
So
me...
this rearward-looking sort of concept of premeditation is a little bit difficult for me to
Your Honor, there's testimony
appreciate.
from the guest on December 31st, before Anna had been killed, that the defendant said his phone was mislaid.
All right, you're right.
So certainly the phone disappeared or was mislaid or whatever happened to the phone, but the defendant represented that his phone was mislaid on December 31st when the New Year's Eve guest was there with Anna. And the defendant also, there was a nanny coming that afternoon. She was scheduled to come about 2 o'clock on the 1st. Anna had told a woman in a nail salon that she and her husband, the defendant, were going out to a adults-only dinner in Marblehead. And certainly I'd suggest that there's no other evidence of that other than that statement. One could infer that the defendant told her that they had plans to go to this party in Marblehead, and that the nanny was going to be there. This would give the defendant, again, a window of time to take action to deal with the disposal of the body of Anna Walshe. Certainly from WF's testimony, it's clear Anna had no plans to tell the defendant about their relationship over the Christmas holiday. She said that he would be devastated, and she also said she did not know what he was capable of. And one can infer that the defendant certainly was seeing those text messages, whether he looked at the phone itself. He made some statements in the police interview claiming that Anna had put the phone upstairs based on a message from someone named Abdullah that had caused some controversy. Certainly the GM, the guest, sort of contradicts that, saying she was using the phone throughout. And other people, AK was receiving text messages from her, and she was texting with WF. Certainly it's a fair inference that the defendant saw those text messages and perhaps realized the true extent of this relationship that they were having, where they were discussing long-term plans, 1, 5, and 10-year plans, and there's a reference to travel that they had taken together. That it's fair to say that the defendant, that might have been something he didn't know about, because based on what at WF's testimony. And also WF, Anna sent a photograph of the house guest herself and the eldest son to WF, and that was something, again, that Mr. Walshe told police about, that she had sent that to him. So I suggest that certainly there's a very fair inference.
Replay that again to me, that last statement.
During one of the police interviews,
yes,
the defendant says that Anna had taken many photographs during the evening and had sent one of them to WF. And that's in, I think it's the third interview, the second or the third interview, Your Honor. And certainly I can find a page site for that.
Thank you, I appreciate that.
And Your Honor, I'd also, cases I'd call the court's attention to are Nadworthy, which is in the Commonwealth's memorandum, it's 396 Mass 342, and Cardarelli, 433 Mass 427.
Can you give me the second one again, please?
433 Mass 427.
Yes.
And these cases indicate that, in some circumstances, evidence of a defendant's activities afterwards, after a murder is committed, can be used to infer motive and malice. And I would suggest here the defendant's activities of looking up how to clean up a crime scene, his activities of purchasing large quantities of cleaning supplies in various stores, and certainly going to different dumpsters and disposing of, one could infer, the victim's body in her possession, certainly is indicative, should be considered as consciousness of guilt, but also as evidence of intent and motive. Your Honor, the court has all of the materials that were presented to the grand jury, the exhibits, which are voluminous, and the transcripts and the memorandum from the Commonwealth. If the court doesn't have any other questions, I would rest on the pleadings. If Your Honor does have questions, I will get the answers to those questions the court does have to the court.
All right. I don't have any questions.
The Commonwealth would ask the court to deny the motion in its entirety.
Right.
Thank you.
Well, I do have a question. Attorney Tipton is suggesting that I have the power under the law to sort of slice the bread, slice the loaf of first-degree murder, such that I could dismiss the indictment in as much as it charges cruel and atrocious. And you haven't talked about that.
Your Honor, I disagree with Mr. Tipton. The Commonwealth does have, there's very few cases on this that the Commonwealth could find. There are 2 unpublished ones in the Commonwealth memorandum that deal with dismissal of so much of an indictment as charges first degree. I'm not sure if they split it so much as to theories, but I would suggest looking at the Riley case, it's clear that if there is evidence to support first degree murder under any theory,
it survives.
It survives.
The indictment survives. Right.
And the Commonwealth may proceed at trial under any theory. Again, it would, and they also
subject to any limitations that might come as a result of a motion.
Again, and I believe that it might be in a footnote, but there's reference to subject to bills of particulars or turning over evidence or information like that. It's not vastly, it's not any different than other rules.
Do you want to discuss what evidence the Commonwealth believes was before this jury on the theory of cruel and atrocious?
Your Honor, I agree with the court's description of it as thin. I don't disagree with that. Again, I would suggest that at this juncture, the court should not cut any theory out of the indictment and should instead, again, I imagine this will be litigated prior to trial. But the Commonwealth, again, if the court finds that there was sufficient evidence of premeditation, this juncture is not the time to make any determination as to what the Commonwealth may or may not do with other theories.
All right. I appreciate the argument on both sides. Attorney Tipton, it's your motion, so you get the second bite at the apple.
It'll be a small one, but because I'm not going to repeat what I said, but ask the Commonwealth judge, if you will. I give you one citation for a case that says a trial court does not have the power to limit can be tried based on what's presented to the grand jury. Those 2 cases they talk about, there's actually more, but I think they're talking about Johnson and Rivera with 128 decisions. They don't have any reasoning or rationale to them. They don't explain it. What we do know is that there is a whole body of case law where the court examines what evidence was presented to the grand jury to determine for the appellate court's reason that there was sufficient evidence in light of a motion and in light of a ruling by the judge of that there was insufficient evidence, and so you can't try the person on a particular theory of murder. I can give you the citations of those cases if the court permits, but I don't think the government here, and they have 2 well-versed appellate attorneys with them, can give you one citation to a case that says you, judge, don't have the power to do what we're asking you to do. And of course, what we're asking you to do is we believe is grounded in the law.
All right. Well, I'll give you a couple of days here or there to bring me up to speed or give me any citations. Obviously, you don't have to file a pleading. You just need to memorialize it and emails to each other that the cases that you're bringing to my attention. If you prefer to file a pleading, that's fine too. And if you give me case law, I'll just note the emails and put them, I'll just have them scanned or something so that there's a record of it happening if you need that.
I will file a very short.
Whatever's easier for you. All right. So that matter's under advisement. Now, so let me say that I was happy to see you all on the Zoom with me last week because we were getting the same information, although I think you were on a Zoom that I was not on because I did not get on the Zoom with Judge Krupp round 2. And the reason I didn't do that, and I apologize, by the way, if you didn't get notice that the 3:15 hearing that I had preliminarily ruminated about got canceled. I don't know if you were on there. I think what happened, honestly, and I don't want to throw anybody under the bus, is that a couple of clerks in Middlesex, in Norfolk, were out in the afternoon, and so it was a slip stitch between what was probably apparent to you, that by virtue of what had happened on Friday, we didn't have an emergency situation, although some could argue otherwise, and did on Friday. I understand from listening to the FTR. But regardless, it seems to me that we have a slightly different situation than maybe we have a different situation than what presents in some of those other cases. And here's how I think it might be different. Maybe I've got it wrong. But let me just start the discussion in this way. It seems to me that ADA McLaughlin is one of the signatories on the agreement as a result of being on the Reed case. And it seems to me that she is on this case, was in the grand jury throughout the 11 or 12 days of the grand jury. So she's intimately familiar with what happened in the grand jury. And otherwise is intimately familiar with what this case is about, because she's still on this case. And being in that unique role as being A, someone who can look at the materials, and B, is assigned to this case, it would seem to me that she would know whether or not there were any materials that were required under Rule 14 and the case law to be produced in this case. And that situation does not replicate itself in all of I don't know if it replicates itself in any of the other cases that people were involved with Judge Krupp last week. I don't care about those cases. I just care about your case, this case. So it would seem to me that we've got a pause. I understand that Judge Casper has put a 30-day pause on everything for people to assess the situation. And it seems to me that what needs to happen is that ADA McLaughlin, who has access to that information, needs to determine as an initial matter whether there is anything in those materials that would be required to be produced under Rule 14. And if there are, we'll deal with that. And if there aren't, then the Commonwealth needs to aver by, I can think of a bunch of different ways, affidavit or otherwise, that there aren't any. Now, the backdrop to this is, as we know, and I'm not going to get the exact language correct, but when we asked for a TUI request earlier in this case, we got we're not giving it to you, but by the way, there's nothing there. That's my paraphrase of it. But that doesn't relieve the Commonwealth of its obligation. So that's how I frame the issue in my mind right now for this case. And it's the defendant's motion that brought us here and alerted me to the issue. I mean, the Commonwealth gave me an email before that, but Attorney Tipton, what do you think about that first shot? Attorney Porges.
So I had a brief discussion with the Commonwealth this morning, and my understanding is that they're filing a request to impound the protective order in which they would show it to the court, show it to us.
They did.
Okay.
Did you get that before the hearing?
We did. So we have the protective order. So our main concern this morning was asking the court to order the Commonwealth to review the material for any exculpatory material or issues. If the court's inclined to do that, then I don't need to be heard further. I would just highlight that a case came down just yesterday that is decidedly on point with this issue. You're smiling because you know, or you're smiling because you...
I think I know.
Okay. It's Commonwealth versus Goparian, and I would refer everyone to the section that discusses possession, custody, and control. Furthermore, the new revised rules under the Mass Rules of Criminal Procedure do a very good job of clearly explaining and expanding what exculpatory means And in this situation, they are arguably in the possession of federal grand jury material that was investigating not only Trooper Proctor, but possibly the integrity of a murder investigation done by this very county, by these very officers. And so I just want to be clear that if the court is going to order it and the government is going to accept the order, that we want to make sure everyone has the same understanding of what exculpatory is. So otherwise, I have nothing further unless the court has any questions.
No, although, let me see if I can get to that paper. So I like to take things, I'm a very logical person, I like to think anyway. So I like to think things step by step. So we'll just go in that manner and we'll cross each bridge when we need to.
Okay.
But I know two particular parts of the order that got my attention.
So when you say order, do you mean the protective order or do you mean the motion that Mr. Tipton filed?
The protective order. And one is paragraph 14, which may bring you somewhere else. And I'm doing this to I'm putting the high beams on for your future, should we need to. Paragraph 14.
I think that's a bridge we'd have to cross.
Yes, and
at one point.
yeah. And the other paragraph that stood out to me as having relevance to this issue is the opening sentence, or all of paragraph 11, with regard to the issue of possession, custody, and control.
The first sentence of paragraph 11?
I think it might be one, yeah, yes.
So,
but we don't have to,
I don't think.
I'm just alerting you to those two paragraphs because there are two things that caught my attention as we move forward on this issue. But let me hear from the Commonwealth first with regard to
Okay.
what, and then I'll go back to the defense. Thank you, Attorney Porges.
Thank you, Your Honor. So it's kind of a unique posture because my co-counsels are not party to viewing the protective order at this juncture. So First Assistant Lisa Beatty has been in contact with the Special Assistant.
What does supervisor mean?
That would have been the chief of the appellate unit at that time who signed the protective order in 2024.
But it says, is that right?
That was the way.
Hold on a second. I just want to go back and see what the. So I refer you to 6B. What does that mean?
When that was drafted, it was relative to supervisors assigned as part of the Karen Reed prosecution.
Right.
So at that time, it was the First Assistant, Lynn Beeland.
But it wasn't just appellate supervisors. It says any supervisors of counsel of record. So anybody that was counsel of record supervisor, which could be multiple levels. I don't really know, haven't studied your corporate structure.
Correct. But as I can say today, well, defense counsel has the opportunity to review the protective order. My co-counsels have not had that opportunity. So Lisa Beatty is in contact with the Special Assistant Attorney General who has an update. She's on Zoom. If Your Honor would like to hear from her, where the office is working with the U.S. Attorney's Office about any future amendments, this protective order, or any additional clarification that the office is seeking about any potential further disclosure. So if you would like to hear from her, she is on Zoom and could fill the court in on, recent updates that occurred this morning.
Yes, please. Welcome, ADA Beatty.
Good morning, Your Honor.
I can't hear you.
You can't hear me?
Hold on.
Try again.
We try that again?
Can you hear me now?
Yes, I can. Thank you. I can't see you anymore, but I can hear you.
Can you hear me now, Your Honor?
Yes, and I can see you.
Okay, great. Thank you. Your Honor, I'm in the process of drafting my notice for Judge Krupp, which is due in 18 minutes. And I got a call from our counsel informing us that at this time we will be able to view the protective order. I know that not all assistant DAs in the office have been able, and I have not been able to view the protective order until I just learned this information. So I can't speak to what's in the order. So that will be able to be changed if there are ADAs who have matters that are in the posture that we are providing discovery and need to address these issues. ADAs will be able to look at the order. In addition, defense counsel, after the state court and defense counsel have signed a protective order, defense counsel will be able to have a copy of the July 21st order as well as the December 2nd protective order. Those are sort of my updates as I'm receiving them now. And then the U.S. Attorney's Office has acknowledged that we need additional accommodations or modifications. I don't know the exact words that they would use, but we have additional requests in order to be able to move forward with cases in a productive manner. And they understand that we're going to continue to engage in dialogue with them and possibly the federal court about how to manage these situations.
All right. Thank you for the update.
And I would just add, the case that came down yesterday is distinguishable because in that matter, the SJC said that the DA's office did not have those materials, that federal materials in, perhaps a protective order remain in the custody of the federal government. That case is distinguishable because a Worcester police officer participated in the interview and had personal knowledge that he could have discussed or disclosed to the ADA, that the ADA did not pursue that information that would have been held by a Worcester police officer. It is distinguishable that pursuant to this order, the materials do remain in the care, custody, and control of the federal government, and the DA's office is prohibited from any further disclosures.
So, but what of my suggestion with regard to your role?
That is a role I understand. That is a role I can represent to the court in a different matter. Upon my review of the materials, I saw a statement that was clearly exculpatory in a different case. I spoke to the U.S. Attorney's Office about that matter and had to advise defense counsel and trial prosecutor in the office that they needed to seek a TUI request.
Right.
I cannot disclose that directly. The U.S. Attorney's Office did not produce that outside the protective order. Defense counsel and the Commonwealth had to seek that information. I provided the Bates stamps numbers to counsel, and they had to go to the U.S. Attorney's Office.
But I'm suggesting that in this case, you do that first step.
And that, I would say, has been done, and it's sort of in the similar posture where we represented to counsel that you need to file a TUI request. Counsel filed a TUI request. The Commonwealth filed its own TUI request. The U.S. Attorney's Office denied that.
But the difference is, in the other case, you identified a document that you believed. What I'm asking the Commonwealth to do, and I'm asking you to do it now in light of the new rules of discovery, not the ones that may have applied when you did it the last time, is to review those materials and identify whether we even have something to worry about.
And the understanding would be trying to, without knowing the defense theory of the case and seeking the broadest, what is most fair.
That's always your burden. That's always your problem. I don't mean you. It's always the prosecution. They make that argument, I don't know, a couple times a week before me when I'm sitting in a criminal session. They can't possibly do as good of a job as me. And yet you have to. That's what the rules require.
And I understand my obligations as a prosecutor to do that. It just becomes a difficult conundrum where if there was a matter, I cannot disclose it to defense counsel and I cannot disclose it to the court.
I understand that.
The order.
I understand that, but why is it not I don't want to say an easy first solution. It puts a huge burden on you. I don't know how much materials there are in there. But why isn't it the first step that we should be taking here is we have somebody assigned to this case that has access to those materials by virtue of the fact that you were assigned to the Reed case. And you have knowledge of this case by virtue of your affiliation with the case and your prior stuff that I said. Why isn't the easy first step for everybody other than you in the courtroom who has to do the man hours, for you to make that analysis and at an initial matter say there is or is not something in the materials that we need to disclose?
And I can represent to the court that the materials that were produced are related to the investigation of the death of John O'Keefe and not any materials related to the investigation of the death of Anna Walsh.
All right. Well, I appreciate that. That falls short of what I'm asking you to do, which is to avert to me, probably by affidavit, that there is or there is not information in. I understand their focus was on there. That doesn't mean that something doesn't make its way in to that file and those records. And I want some assurance that somebody has laid eyes on those documents and recognizing that it might be unlikely that there's anything to do with this defendant in those records, close that door.
And to do so, Your Honor, I believe we would have to seek guidance from the U.S. Attorney's Office to make sure it's not outside the confines of the protective order. Because the way the protective order says.
Well, the order allows you to review it, right? The order allows you to review those materials.
For use in the state court action against Karen Reed.
So have you sought guidance from the court with regard to for review in connection with any other cases?
I believe that is what ADA-BD has represented with where the Commonwealth can't represent itself in federal court. A assistant attorney general has been appointed, and I believe there is ongoing discussions.
All right. We're headed to another meeting on this probably next week because I don't want this to, I'm not going to put this out till the 30th, the 30 days, and we're in another fire drill. So we'll talk about that.
Your Honor, just briefly, I'm certainly sympathetic to the position that ADA McLaughlin finds herself in. It's clear that she understands her obligations under Rule 14, under Brady, but I do disagree with her analysis of Goparian. When it talks about reviewing material, the detective in Worcester was a detective on the homicide case in Goparian. And so just for a picture, ADA McLaughlin is an ADA, part of the prosecution team in this matter. The cop in Goparian randomly happened to be present for a proffer on an unrelated case in which someone made a statement. So Goparian went on to specifically state that the law demands at the very least that the prosecutors ask other members of the prosecution team whether exculpatory information exists. So to me, that combined with Brady and combined with Goparian impose a duty for her to look. I understand that she is, and I agree, the two paragraphs on the protective order I think are very clear, but I don't think it's an automatic, just automatically resolves her or the rest of the team to just not look because they can't. So I think it's a long way of me saying we might have to end up litigating something in federal court. And so I think we do need to kind of figure if the motion, the protective order can be expanded insofar as ADA McLaughlin has to do a specific review for this case, guided by the revised Mass Rules of Criminal Procedure, Section 14, that gives a very clear description of what in fact is considered exculpatory.
Your Honor, may I be heard briefly? I apologize for interrupting. These are exactly the issues that we are in communication with the U.S. Attorney's Office, and I can promise the court that I can address this specific case and this specific request that this court is making at this time when I speak with them, if you would give us some additional time.
I will, and I appreciate you specifically raising this because I think we have I don't want to get, particularly in light of the schedule in this case, I don't want to get dragged down with the other cases that are not in a similar posture. The unique situation here is that ADA McLaughlin has already seen the materials. It's not disclosure to any, she saw them in connection with another task, but it's not like a new person is coming on or a new set of people are coming on at this moment. So that might give us a swifter direction to a better result. So I'll give you some time to see if we can sort that out.
Thank you very much.
All right. So those are the motions that we had to hear. We're going to set a status on this last issue for next week. Clerk, what do we have?
Judges, we're picking this date. I'm just hoping we can appear by Zoom. Attorney Porges is going to be on trial. I'm on vacation, but I'm glad to appear by Zoom.
Yes. You're welcome here, and you're welcome to appear by Zoom.
Thank you, Your Honor.
So, Madam Clerk, what does our next week look like?
Next Friday.
Okay.
Your Honor, if you're willing to, I'm sorry, Madam Clerk, if everyone's available for a 2 or 3 p.m., I might be able to get permission just to hop on at court.
Okay.
But or I might not. I'm just throwing it out there.
That's fine, Your Honor.
Is 2 or 3 p.m. better?
Well, I don't want everyone to schedule around me. I mean, I do, but I could be in the middle of a witness and the judge is like, I can't let you.
Right.
But it's just, there's a higher likelihood.
Well, why don't we schedule it at 2, knowing that probably somebody could, I don't know who you're before, but they might be able, they take another 10 minutes.
And he's lovely. I'm sure he would. I just don't know where we're going to be.
So Friday the 1st?
No, any day but Friday.
Oh, any day but Friday. Sorry, I apologize. The 31st is that available?
Yeah. We can do Friday the 1st.
Whatever works for the court.
So why don't we do Friday the 1st at 2 p.m.?
Friday the 1st at 2 p.m.
Can I trouble Madam Clerk to issue a Zoom HABE to Norfolk for Mr. Walsh?
Yes, I'll request it through the Norfolk County Clerk.
Thank you. Oh, I'm sorry. I can do that too.
That's all right. We'll be in contact with them.
Thank you.
The motion to dismiss is under advisement. The matter is continued to August 1st at 2 p.m. here at Plymouth Superior Court. A Zoom HABE will issue for Mr. Walsh. All parties may appear by Zoom?
They may.
Okay. All right, thank you, Counsel.
Thank you, Your Honor. Thank you, Madam Clerk.
What? All rise.
Hello, my beautiful people. Who's here? Hello, peoples. That was like, I've never been more bored with a judge ever. I don't know if you guys were as bored as I was. Declan. That was painful. However, I think that if McLaughlin has already seen the stuff, she should be able to look at it again, even if it's a different case. These kids today, woof, let me tell you. Yep, we have to wait until the first at 2 o'clock. That's the next hearing. She took it under advisement. So now we just wait more time. Wait some more. Here, let me turn this on. How are my peoples? My peoples are here. How are you guys? I have an animal who's stalking me for my sandwich. Because I have a sandwich. Now he's on my button. Really? Do you see what I'm dealing with? When it's not him, it's the cats. But I wanted to show you, because you guys have asked and you've been part of this whole time. When you see one of the babies, look how big the babies are.
Why did it go like that?
It's a baby. Look how big they are.
To be honest, I kind of want
Remember when I got them? They were like just big, little things. Now they're big and they're strong and they're beautifuls. She's a big girl, huh? I'm a big girl. So this is actually we'll say the smallest one, believe it or not. Let me get the other ones. Say hi, baby. Say hi. Say hi. Oh. What? Hulk Hogan died? What? That's the third one. Oh my gosh. That's so weird. And then we have this baby. She was the middle sized. She has a little black dot. At 3 and 3 days. That's easy. Ozzy, Theo. There you go. This is the fatty. That's the biggest one we've had from the beginning. Huh. So I'm a fatty son. I'm a pretty fatty. They're snowflakes, so they're not like the normal colors. So they are a little snowflake. You know what's odd is my best friend's boyfriend has been doing work at Hulk Hogan's house. So it's weird to hear that because he literally has been there all week, the last 2 weeks. That's crazy. Let me look it up and see what we can find out. Dead at 7. Oh, wow. This is crazy, guys. Stop. Crazy. Look at this. Let's see.
Okay, wait. Can you give me a help? You hold it and then you stay in the drop.
Yeah, Hulk Hogan, dead at 71.
I'm at 2.
Theo Huxtable from the Cosbys, Malcolm Jamal Warner died on Monday from drowning in a riptide. And then Ozzy Osbourne died yesterday. Yesterday or 2 days ago?
I knew he was right there.
No, it's not him. Trust me, I know that. But yeah, they live right there near him. And so let's see what it says. It says wrestling legend Hulk Hogan has died at 71. Okay. Medics were dispatched to his house in Clearwater.
Okay, wait.
While operators stating it was regarding a cardiac arrest.
Okay, distract him.
Told a slew of police cars and EMTs were parked outside of Hogan's home, and the icon was carried on a stretcher into the ambulance. So that's so crazy to me. I have to text my husband.
Oh yeah. Dang, that was horrible. I think we're at 100.
I'm just shocked right now.
Probably because he stepped in his.
He's so you guys, Hulk Hogan is huge in the area that we in Clearwater.
Look, there's not a sprint button for me.
I'm shocked right now.
You just run straight forward.
I'm gonna text my best friend. I'm gonna see where her boyfriend is. I'm gonna say, hey, where's Mike?
Oh,
Very young, very young. And my brother just said, damn.
Hey, you wanna go over there? There's a bathroom.
These are like, you know what's sad is like these are people we grew up with. And I remember like when my mom was talking about people that she grew up with, you know, like idols or stars that she grew up with. Yeah.
Okay, I found the
He was up in that area a lot then. Okay.
I dare you to go find. Is that a monster down there?
Crazy, like shocked right now. I don't like feeling like people that are our age. Yeah, he was out swimming in the ocean off Costa Rica, I think, with his daughter, and it was a rip tide that he got caught in, and he drowned. And they did cardiac. He went to cardiac arrest, of course. They did a CPR, but he didn't come back. They couldn't get him back, and so
I distracted. Okay, go. No, look.
Yeah,
Did you just get damaged?
I'm shocked right now.
You did it?
Like, that's the 3 though. They say it comes in 3s. This is just a few weeks ago. Hogan's wife Sky denied he was in coma, stating his heart was strong as recovering from surgeries. We broke the story last month that there was rumblings he was on his deathbed, but we were told at the time that dealing with symptoms of a neck procedure that underwent in May. He transformed professional wrestling into family entertainment. Let's see. There's The Rock and Hulk Hogan WrestleMania. He was inducted into the WWE Hall of Fame in 2005 and was removed in 2015 after a scandal erupted over racist comments while he was being secretly recorded during a sexual encounter. Gawker posted the clip and Hulk subsequently sued, winning the lawsuit. He was inducted a second time in the WWE into 2020, this time as a member of NWO. Hulk was the star of 2004 Republican National Convention when he set the world ablaze with theatrics. Amazing, successful career movie. He was in Rocky 3. No Holds Barred, Suburban Commando, Mr. Nanny. He starred in the VH1 reality hit show Hogan's Best with his family, Linda, Nick, and Brooke. What's amazing is he had scores of surgeries as a result of his wrestling injuries. And he told Harvey during a taping of Objectified that he had no original body parts left. The last time we spoke, Hulk was back in May. He was launching the Real American Freestyle and Amateur Wrestling League. The first event is August 30th on Fox Nation. So
What does it look like?
That he did. Whew. I really think Sharon, if something happens, it's because Sharon dies of a broken heart, honestly.
Is that what Pennywise is?
She's loved that man since she was 18 years old. And that's a long time to love somebody. But like my husband said, that man was a science experiment. He did so many drugs. They need to do research on his body because I don't know how. He was I think he was dead for 10 years before we actually knew about it.
Why are you squinting?
Yeah. And I mean, and honestly, I wasn't even that big of a fan of Ozzy Osbourne. I liked some of his music when I was a kid, but not a huge fan until the Osbourne show was on MTV, and then I fell in love with them as a family. So I've always had that. She's so feisty, and he was just whatever.
Yeah.
It's just crazy.
Oh my gosh, 58.
So, well, you guys,
What?
let's see if there's anything else that we need to know.
What does that do?
I will always say, I'll also say, sorry, always, I can't even talk right now. I'm so tired. You guys can't tell. I have bags under my eyes today. I will say that if you guys get a chance, and I don't want to play it today, I was going to do like a little stream on it, but Brian Inton did a story on the Idaho 4, Xana, Kaylee, and Ethan and Madison. And they were released new paperwork from the Moscow Police Department. Now, I do know that right before the hearing, the day before the hearing, I guess the Gonzalez's family was called in to speak about it so that they knew what was going to be released. And it's not good. It's not. Declan, a little lower, please. It is not, I don't believe, after what I've heard today on Brian Inton's interview, I do not believe that Brian Koberger was after Kaylee, or after Madison. I believe he was after Kaylee. I believe maybe Kaylee didn't give him attention that he thought he deserved or wanted, maybe when he tried to talk to her. Yeah. Did I get the book? What book, Kate? I don't know what you're talking about. I just know that Brian Inton here on YouTube did a Declan. Go take your meds. You can tell you haven't taken them. Let's see. So it's Brian Inton Investigates. Right here.
Okay, hold on.
Oh, I didn't. I'll have to see it. You want to hear all my thoughts? My thoughts aren't that special, Danny, I promise. I mean, somebody already told us on a comment on one of the other videos that Amy was the one they came to see and that I just wasn't fit for them. So we'll see. I told them just not to watch anymore if they didn't like me, but that's fine. You don't have to like me, but you guys have to, because you guys are my family and I make you. But Brian Inton released a video, this one right here.
Hey guys,
I'm not gonna play it. But this is the video if you guys want to. I do not. You're so sweet, Hate. I love you. But I do not have no tea. But he released a video today. I believe it was early this morning. I watched it at like 6 o'clock this morning. You only like me because of my children. That's great. Thanks, Hate. I'm kidding. Oh, now look, my children is showing up. My child is here to say hello. Hi. Go away. Bye. Go. Booty shorts boy. He's wearing shorts that are way too short for him. I don't know why. I'm like, you have booty shorts on right now. But if you guys want to know some of the details of the murder, oh God, you missed all the boring stuff. That judge bored the crap out of me, Danny. If you want to know more details of the murder, if that's, I listen to that stuff because I kind of want to put it in my head what happened, the person, why he did it, why it was so intense. I mean, I'll play it if you guys want me to play it. This is the first half of it. The second, they do also, they play Dylan's. He plays Dylan's entire statement in the middle, and then he plays all of Olivia's. So it's up to you guys. If you want me to play it, I'll play it. But I will tell you, there's a trigger warning. It can get graphic. So you're good for it? Everybody's good? It can be graphic, so I just want to make sure you guys know that before I do it. So you're here for graphic. Heather, I love you. You are me. Heather, we are the same person, I think. Play it. Okay, I'm playing it. Let me see.
I'm outside the courthouse in Boise, Idaho. This is where the Brian Kohberger sentencing was today. We just got hundreds of pages of new documents that were just released by Moscow PD, investigative documents we've never seen before. I'm going to go through all the new details with you in this episode. Also, I was in court today. I was sitting right in the courtroom, right near the family members. I'll let you know all the key elements from court today, everything from the documents, everything from court. I'm going to sit on the step right here. And tell you guys everything that happened today. All right, so as you can imagine, it was a long, emotional day here. Crazy. It's been 2.5 years, and this is how it all ended. First of all, I just want to say my heart goes out to the family members of Kaylee, Maddie, Xana, and Ethan. They showed such incredible strength and composure throughout this entire thing, and it's really just incredible. So I want to start by saying that. I'm going to get to everything again that happened in court. I'm going to walk you through the whole process to get here super early to get in. I'm going to give you all the details on that. But first, I want to go through, we just got a whole treasure trove of documents from Moscow Police Department. They had a press conference earlier. The chief said, we're going to upload a ton of documents that the media will be able to get this afternoon, and they did it. And we have a whole team that's been going through them nonstop. Trying to highlight anything that's new. I'm sure this is going to be the first of many document dumps, but I want to go through, and some of this stuff is hard to talk about and listen to, and the details are difficult. And again, I think of the families. But I'm going to go through here some of this stuff that just came out in these new documents. Need these reading glasses now that I turned 40. So these are police reports that came.
I want to say that Brian Inton is really cute. I don't know why. He's such a nerdy, cute guy. And he put his glasses on just now, and I was like, oh my gosh. It's like Superman, but he put the glasses on and became cuter. I might be the only one. It's okay. I need Tonka in my life. Tonka is our support dog. I need them from my cats. They're my dog, my cats, and my dogs. They're driving me crazy. I need Tonka in my life. But all right, I'm gonna play it now.
From an officer, one of the first officers who responded to the scene, and we've now got the reports of exactly what they saw when they arrived. The officer wrote, "This is from 112 King Road, of course, after the murders, when the officers arrived. In the third floor bedroom, I observed 2 females laying in bed, which appeared to have been stabbed to death. The female laying on the left half of the bed, as I looked at it from the doorway, was unrecognizable. Her face was completely disfigured and was stabbed several times. I was unable to comprehend exactly what I was looking at while trying to discern the nature of the injuries. The second female on the right half of the bed had multiple stab wounds. The comforter was soaked in blood, and a pool of blood was present." This is from another one of the police reports. "I looked inside the bedroom Xana was laying, and it was obvious an intense struggle had occurred. Xana was obviously deceased. There was blood smeared on various items in the room and all over the floor. There was a blood cast off on the walls in various places, including above Xana's body.
Xana was on her back on the floor in the center of the room with her head towards the west. Xana was in her underwear and a long-sleeved gray shirt. Both her shirt and underwear were covered in blood. Xana's face and body was covered in dried blood. I could see what appeared to be defensive knife wounds on Xana's hands. There was a deep gash on Xana's left hand between her pointer finger and her thumb. So defensive knife wounds would indicate to me that they believe that Xana somehow fought back. Another report says Kaylee and Madison were covered by a pink blanket, which was covered in blood. There was a large pool of blood near Kaylee's midsection. Madison appeared to be laying up against Kaylee. Madison had what appeared to be wounds to her forearm and hands. Madison had a gash under her right eye, which appeared to go from the corner of her eye to her nose. Kaylee was unrecognizable as her facial structure was extremely damaged. I think this explains why the Gonzalez's why all the families are so heartbroken. I know the Gonzalez's met with the prosecution yesterday, the day before the sentencing. They got more information. I was in touch with them. They were very upset after that meeting by the details that they had learned, just heartbroken. And this is some of what they've learned. I mean, for them to have to hear that Kaylee's face was unrecognizable is just, there are no words. There's no words. So this is from another report where they're interviewing someone who knows Kaylee about something that Kaylee had told them. I'm going to kind of hop around here because we went through all these different reports. And this person just goes by Jay. Jay then told me where she had heard from others that Kaylee had seen some random guy behind the house when she took Murphy out to go pee. Jay also heard of an incident where some random guy followed Kaylee around Winco and followed her out of the store, and she thought he tried to get into her car. Jay was not sure for sure who she heard from, but B&D could tell us more. I thought that was interesting. I know from Olivia, when I've talked to her, that she said that Kaylee was afraid of a stalker. I'm going to tell you more about the press conference today in a minute, but police did say that they don't have any evidence that it was one of the girls that was targeted, and they don't believe that there was any connection between Brian Koberger and any of the girls. They've never officially said before that there was no social media connection. They confirmed that today. So that is new and that is significant. Again, some of this stuff is really difficult. I'm going to read you. These are the autopsy results. We've never had this before.
Heather, from my understanding, they did not have to, whoever ID'd the bodies, I don't know who did, but the parents had no idea what had actually happened. They knew from what Steve Gonzalez said on News Nation the other day or last week was that they knew that they believed she was hit with something else as well, that there was a second weapon, but that's what they believe, because that's what they, as a family, had found out a lot of information prior to what the police had released. But they did not, they also said that it looked like Kaylee had red marks around her face, or it looked like that she had been gagged, possibly by a hand, like his hand, which for him to have all this to happen and only one speck of DNA was left when you're using a knife. Yeah, they just were called in to the police station this month, the day before this, to talk about what was being released, and what they could find out stuff, because they never actually knew what happened. Xana was stabbed over, I think he said 50 times, and then it might be 50, it might be a little bit more. He's going to go over that here in the autopsy report, but Xana went down fighting. She went down, she was not going to let him win. But to me, it sounds like he was after Kaylee and not Madison, because for some reason he took and made Kaylee unrecognizable. But she also only had, I mean, she had not near as many stab wounds as other people. So it's like my brain can't wrap around it. Yeah, her sister would have fucking kicked his ass. Let me tell you, Olivia is not wrong when she said that. That lady is the feistiness of the Gonzalez family women is something that I idolize, because I would be exactly the same way. And I am so thankful that the judge allowed them to say exactly what they wanted to say. Like, I can't be any more thankful that he did and what he said, what the judge himself said. I don't think I've ever watched a case with victim impact statements to where the DA or the prosecutors, as well as the judge, were in tears as they spoke. I personally have never watched a case where a judge was in tears as he spoke about giving a sentence and what this man did to these children. So I was very, that judge was the most eloquent, and he made it to where he can never make money off of them. And if he does, it goes back to the families. He has to repay all the funeral costs to each family. He has to pay $50,000 for each count. There's 5 counts, $50,000 for each count, and another $5,000 on top of that for each count that are paid directly to the families as well. So if somebody tries to make a book with him, good luck, because he ain't getting that money. If someone tries to do a movie and he's the one that they're paying for it, no. 9%. In fact, nobody should give him the satisfaction to ever let him tell his story now. He doesn't get that right. Unless he's going to tell it to the families in their faces, nobody should ever be able to hear from him what happened. And I will stand on it till my dying day. That man is a monster. That man is messed up in the head. And the fact that he went over and studied criminology and did the things that he did so that he could go and commit this crime, and he thinks he's going to live on in infamy, fuck you. No, you're not. I will never say his name again. Nothing. The only thing I will ever speak on ever again with this case that comes to anything is these children, these kids, Maddie, Xana, Ethan, and Kaylee. These are the only ones that ever get to be talked about. So if that name comes up in here ever again, it's going to be BK or monster piece of shit in Idaho. Because these are the ones who don't matter. And I'm sorry, I went off my high horse and I shouldn't have. But no longer, he's not allowed. No longer is he allowed to speak. He is lost that fucking right. I was the first one you thought. Let's just say it was a joke my sister used to say all the time. My sister's 5 years older than me, and she would be like, don't mess with me. You don't want to mess with my sister because she'll come after you. And it's kind of true. I'm the middle child. It's middle child syndrome, I guess. I don't know. I'm middle child. I was born a redhead, but it grew out, strawberry blonde, and it grew out blonde when I was like 3 months old, started going blonde. I had red roots or red tips and blonde ends, and I was a towhead my whole life. But I do hope this man goes. I hope someone takes him out quickly. Not quickly. I want them to take him out slowly in a painful death, but I want it to happen sooner rather than later, I guess I would say. Not quickly. I can't. they are the ones whose memories, and that's what I feel like. I don't want to call them the Idaho Four ever again, because they are more than four. They are individual children, and their lives meant something. And I firmly believe that there will be laws put in place because of their deaths. And I really hope that those bills take effect. And I know that they all have, there's nonprofits for them. But I'm devastated listening to this. So I'm going to let you listen to the autopsy reports now before I go off any further and tangent.
You know, it's public record now. Obviously, we would never show the photos. We would never have access to the photos, but I do want to explain to you the extent of the injuries. Ethan Chapin's fatal injury was from a stab wound under his left clavicle, which severed his subclavian vein. I hope I'm saying this right, and subclavian artery, maybe subclavian artery, and also his jugular vein was severed. Ethan only had sharp force injuries. Xana Kernodle's fatal injuries were from one laceration in her right lung and 2 lacerations in her heart. Kernodle had 50 plus stab wounds, mostly defensive. Xana only had sharp force injuries. Madison Mogen's fatal injuries included a left lung laceration and a liver laceration. Madison only had sharp force injuries. Keely Gonzalez's fatal injuries included a left lung laceration, a liver laceration, 2 subdural bleeds, and a stab behind her clavicle, which cut her subclavian vein. Again, I'm sorry, you guys will message me. I'm sure I said that wrong. An artery. Kaylee had signs of sharp force injuries, asphyxial injuries, and blunt force injuries. Kaylee had 20 stab wounds. So Kaylee had 20 stab wounds. Xana had 50 plus stab wounds. I mean, just brutal. This guy was just I don't want to curse, but a monster. So that was what was new today from the reports with the autopsy. This is another section of new documents that we found that's new. This is what an inmate was saying about Brian Kohberger. So they apparently interviewed some inmates. Kohberger, of course, was in the jail in Latah County first, which is where Moscow is. Then he was in the jail here in Boise. He's transferred here because when the trial got transferred here. And then he was soon he'll be sent to the prison system here in Idaho. But this is what inmates were saying about Brian Kohberger. An inmate in the same facility as Kohberger stated he is a fucking weirdo and said if he wasn't worried about legal repercussions, he would have physically assaulted Kohberger. When asked if he thinks Kohberger is guilty, the inmate said, his Kohberger eyes tell a story. A lot of you guys have mentioned the eyes. I've noticed his eyes. I'm going to tell you about what he would look like in court today, but interesting that was from an inmate. This is from another inmate. Inmate who was housed next to Kohberger from August 2024 to September 2024 at Latah County Jail said Kohberger was the smartest person he had encountered while in confinement, but became annoying because of habits like washing his hands dozens of times per day and spending 45 minutes to 1 hour in the shower. He said Kohberger would be awake all night and only take a nap during the day. He said he could hear Kohberger moving around all night. So kind of interesting to hear those things from some of the inmates. And again, that came from the new documents. So I want to walk you through really quickly the press conference. There was a press conference after, then I'll get to court. Just this kind of relates to some of the investigative stuff. I told you already, Moscow police never found a link on social media between Kohberger and the victims. They have no information about where Kohberger's clothes or knife are. So they said they have no idea. Like they don't know where the knife is and they don't know where his clothes are from that day. And I asked a question at the press conference, do you think that there may have been another murder weapon used? And the police flat out said no other murder weapon used. K-bar knife was the only murder weapon. Papa Roger, this is big because we've all talked about this. Papa Roger's social media account not connected to Brian Kohberger, period. They did investigation. They confirmed Papa Roger's social media account is not connected to Brian Kohberger. And the Idaho Attorney General today called the murders one of the darkest crimes in Idaho history. The prosecutor talked a lot about, he was very emotional about the whole thing. He was choking up at the presser again when he was thanking his teams and all the different agencies. They all work together. He went into detail about all of that. In terms of court today, got here super early. The line wrapped around the building. We were let in, and some people stayed here the whole night. I was nervous about getting a seat. I ended up getting a seat. Went through security. Got upstairs. We were put into a holding room. You get given, I don't think I have my little white ticket anymore, but they gave us a little white ticket if you were able to make it in. So waited in the holding room for a while. We got into the courtroom. It's interesting. All the media sat on one side of the courtroom and all the families were on the other side. And for some reason, they sat me right in the middle of all the families, which you guys know I'm pretty close to the families, especially the Gonzalez family. And I was right behind the Gonzalez family. So I don't know. It was nice to be close to them, I guess. I don't know if that's the right word. I was, I was able to say hi to Olivia and I don't know. I felt a little more, I was nervous about the whole thing, honestly. And I knew it was going to be emotional. I've been so invested in this case. Maybe I just felt more comfortable being over there by them because I've gotten to know them all. So hearing started, everyone was kind of on pins and needles. It immediately became very emotional. I know it was the most emotional, I think the most emotional situation I've ever been in my entire life. You could only see the cameras from the live feed, but where I was sitting in the middle of all the families, they were all sobbing the whole time and holding each other and crying and holding hands and rubbing each other's shoulders. But just that constant sound of whimpering throughout the entire thing was really just heartbreaking. And the way the families were supporting each other was really, really touching. And again, they're just so strong. They're all so strong. The Kobergers, Brian Koberger's mom was there and Brian Koberger's sister was there. I did not see his dad there today. His dad was at the plea hearing. They were on the other side though. And where I was sitting behind the Gonzalez's, I kind of had to peer around this pillar to see them and to see Brian Koberger. So a ton of family members spoke. I have the whole live stream on the YouTube channel if you want to go back and watch. Dylan Mortensen, first of all, this woman is so incredibly strong with what she's been through to be the surviving roommate. And she was sobbing before she even got up there. And the bravery it took for her to go, walk up, sit in that chair, and she took a moment to compose herself. And she was shaking. I could see her shaking. And she so bravely made her statement and just broke down. And she came back. She was sitting in front. I was sitting behind the Gonzalez's. She was sitting in front of the Gonzalez's. She came back in and she sat down. And I assume it was her mom. I mean, they just went into this hug, and she was in hysterics, Dylan. And her mom was then hysterical. And then people sitting behind her were putting their hands on her shoulder, and she was shaking. I mean, she was literally she was uncontrollably shaking. And again, I just kept thinking about what she's been through and the bravery it took not only to speak to the court, but to speak with Brian Koberger sitting right there and make eye contact with him, the man who killed all of your friends and had this impact on your life. So I want to play for you the full, I think it's important to, I want to play for you the full Dylan Mortensen victim impact statement. And I just think, I don't know, I'm just blown away by her strength. And I think it shows, we think so much about the victims' families, which are obviously important and have been through hell, but think about Dylan and Bethany. So listen to what Dylan said.
What happened that night changed everything. Because of him, for a beautiful, genuine, compassionate people were taken from this world for no reason. He didn't just take their lives. He took the light they carried into every room. He took away how they made everyone feel loved and full of joy. He took away the ability for me to tell them that I love them and that I'm so proud of them. He took away who they were becoming and the futures they were going to have. He took away birthdays, graduations, celebrations, and all the memories that we were supposed to make. All of it is gone. And all the people who loved them are just left to carry that weight forever. He didn't just take them from the world. He took them from me, my friends, my people who felt like my home, the people I looked up to and adored more than anyone. He took away my ability to trust the world around me. What he did shattered me in places I didn't know could break. I was barely 19 when he did this. We had just celebrated my birthday at the end of September. I should have been figuring out who I was. I should have been having the college experience and starting to establish my future. Instead, I was forced to learn how to survive the unimaginable. I couldn't be alone. I had to sleep in my mom's bed because I was too terrified to close my eyes. Terrified that if I blinked, someone might be there. I made escape plans everywhere I went. If something happens, how do I get out? What can I use to defend myself? Who can help? And then there are the panic attacks. The kind that slam into me like a tsunami out of nowhere. I can't breathe. I can't think. I can't stop shaking. All I can do is scream because the emotional pain and the grief is too much to handle. My chest feels like it's caving in. Sometimes I drop to the floor with my heart racing, convinced something is very wrong. It's far beyond anxiety. It's my body reliving everything over and over again. My nervous system never got the message that it is over, and it won't let me forget what he did to them. People call me strong. They say I'm a survivor, but they don't see what my new reality looks like. They don't see the panic attacks, the hypervigilance, the exhaustion, the way I scan every room I enter, the way I flinch at sudden sounds. They don't know how heavy it is to carry so much pain and still be expected to keep going, and that's because of him. He stole parts of me I may never get back. He took the version of me who didn't constantly ask, what if it happens again? What if next time I don't survive? He may have shattered parts of me, but I'm still putting myself back together. Piece by piece, I'm learning how to live in this new version of life. It is not easy. It hurts, but I'm still trying. And I'm not trying just for me. I'm trying for them, my friends. About a year ago, I had a dream about them. I got to say goodbye. I told them I won't be able to see you again, so I need to tell you goodbye. They all kept asking why, and all I could say was, I can't tell you, but I have to. When I woke up, I felt shattered and heartbroken, but also strangely grateful. Like maybe in some way that dream gave us the goodbye we never got. Still, no dream can replace them, and no goodbye will ever feel finished. He is a hollow vessel, something less than human. a body without empathy, without remorse. He chose destruction. He chose evil. He feels nothing. He tried to take everything from me. My friends, my safety, my identity, my future. He took their lives, but I will continue trying to be like them, to make them proud. Living is how I honor them. Speaking today is to help me find some sort of justice for them. And I will never let him take that from me. He may have taken so much from me, but he will never get to take my voice. He will never take the memories I had with them. He will never erase the love we shared, the laughs we had, or the way they made me feel seen and whole. Those things are mine. They are sacred, and he will never touch them. I get to feel sadness. I get to feel rage. I get to feel joy even when it's hard. I get to feel love even when it hurts. I get to live. And while I will still live with this pain, at least I get to live my life. He will stay here, empty, forgotten, and powerless.
So that was a lot when Dylan spoke. And every single speech was highly emotional. I'm not gonna lie. I mean, I got choked up several times. I think you'd have to be like not human not to feel a very high level of emotion in court today. Olivia Gonzalez also spoke. That's Kaylee's sister. And just for full transparency, and I haven't really spoken about this, I've gotten to know most of the families in one degree or another. Olivia is someone who I feel that I've gotten close to. Of course, I'm a reporter. It's a reporter relationship. I'm not going to say she's like my friend. But I care for Olivia, and, you know, we have been in touch a lot throughout this whole thing. And I knew that she wanted to address Brian Koberger directly. She had told me that. And she was concerned, was it going to be allowed? But she didn't want to, like, give him anything by showing her grief or by talking all about Kaylee, or she told me she didn't want it to be like a funeral for Kaylee. She wanted to address him, and she did. And this woman, Olivia, is a badass. I mean, she is a badass. And, you know, Steve Gonzalez is really, you know, is a strong guy, and he holds that family up, but so does Olivia. Behind the scenes, you guys don't see it as much because Steve does a lot of the talking, but Olivia is holding that family together in a lot of ways. And so she spoke to Brian Koberger. I mean, she locked eyes with Brian Koberger. They all did, but she stared that man in the eyes, and he stared back at her, and she laid into him. And people clapped at the end, and she laid into him. So again, just like with Dylan, I want you to see the full Olivia Gonzalez victim impact statement.
My name is Olivia, and I'm the big sister of Kaylee Gonzalez, and I was blessed to love Madison Mogan as a sister too. I'm not here today to speak in grief. I'm here to speak in truth. Because the truth is, my sister Kaylee and her best friend Maddie were not yours to take. They were not yours to study, to stalk, or to silence. They were two pieces of a whole, the perfect yin and yang. They are everything that you could never be. Loved, accepted, vibrant, accomplished, brave, and powerful. Because the truth about Kaylee and Maddie is they would have been kind to you. If you had approached them in their everyday lives, they would have given you directions, thanked you for the compliment, or awkwardly giggled to make your own words less uncomfortable for you. In a world that rejected you, they would have shown mercy. Because the truth is, I'm angry. Every day I'm angry. I'm left shouting at the inside of my own head everything I wish I could say to you. The truth about me is when I heard the news, I didn't cry. I listened for them. I promised them I would, that I would fight for them, that I would show up no matter what it cost me. I swore I'd never let them feel alone. Because you see, I've always been their heavyweight. I've always been the one to fight the battles they didn't feel ready to fight themselves. All it ever took was a call, and they knew I would handle it for them, no matter the time, no matter the cost. They could wave their white flag because they knew I would never back down, not for them, and not even death could change that. Somewhere along the line, I started to think about what I would say to them if I was given just one last chance. If I could gather enough heartbreak or love or sacrifice or whatever it took to get just one message across, what would I say? Throughout this entire process, I've written my feelings down at every moment, my wishes, my love, my denial, my anger. And as one final act of love, I'd planned to read these thoughts, even jarring and discombobulating and not even making sense. Because for me, that was true love. As bare and as naked as it could be, not laced in pretty words or dressed for the occasion, but written through bleary eyes at 2 a.m. with clenched fists, angry at this reality. My true final act of love was to continue on without them, for them. That dream to read aloud my love to them, to bring meaning through pain, was the latest blow in realizing you don't deserve it. And Kaylee and Maddie don't need it. Kaylee and Maddie have always known my love, and they would never ask me to prove it by further victimizing myself to a defendant who has shown no guilt, no remorse, no apprehension. They would say to me, "Why would you give the satisfaction of showing vulnerability now? You promised you would never back down." And for that clarity, I'm thankful. I won't stand here and give you what you want. I won't offer you tears. I won't offer you trembling. Disappointments like you thrive on pain, on fear, and on the illusion of power. And I won't feed your beast. Instead, I will call you what you are: sociopath, psychopath, murderer. I will ask the questions that reverberate violently in my own head, so loudly that I can't think straight most any day. Some of these might be familiar, so sit up straight when I talk to you. How was your life right before you murdered my sisters? Did you prepare for the crime before leaving your apartment? Please detail what you were thinking and feeling at this time. Why did you choose my sisters? Before making your move, did you approach my sisters? Detail what you were thinking and feeling. Before leaving their home, is there anything else you did? How does it feel to know the only thing you failed more miserably at than being a murderer is trying to be a rapper? Did you recently start shaving or manually pulling out your eyebrows? Why November 13th? Did you truly think your Amazon purchase was untraceable because you used a gift card? How do you find it enjoyable to stargaze with such a severe case of visual snow? Where is the murder weapon? The clothes you wore that night? What did you bring into the house with you? What was the second weapon you used on Kaylee? What were Kaylee's last words? Please describe in detail the level of anxiety you must have felt when you heard the Bearcat pull up to your family home on December 30th, 2022. Which do you regret more? Returning to the crime scene 5 hours later, or never, ever going back to Moscow, not even once, after stalking them there for months? If you were really smart, do you think you'd be here right now? What's it like needing this much attention just to feel real? You're terrified of being ordinary, aren't you? Do you feel anything at all? Or are you exactly what you always feared? Nothing. If you're so powerful, then why are you still hiding, defendant? You see, I'm here today as me. But who are you? Let's try to take off your mask and see. You didn't create devastation. You revealed it in yourself. And that darkness you carry, that emptiness, you'll sit with it long after this is over. That is your sentence. And it was written on the wall long before you ever pled guilty. You didn't win. You just exposed yourself as the coward you are. You're a delusional, pathetic, hypochondriac loser who thought you were so much smarter than everybody else. Constantly scolding, turning your nose up to grammar mistakes, nitpicking and criticizing others. You wanted so badly to be different, to be special, to be better, to be deep, to be mysterious. You found yourself thinking you were better than everyone else, and you thought you could figure out the human psyche and see through it, all while tweaked out on heroin. Lurking in the shadows made you feel powerful because no one ever paid you any attention in the light. You thought you were exceptional, all because of a grade on a paper. You thought you were elite because your online IQ test from 2010 told you so. All of that effort just to seem important. It's desperate. There is a name for your condition, though. Your inflated ego just didn't allow you to see it. Wannabe. You act like no one could ever understand your mind, but the truth is you're basic. You're a textbook case of insecurity disguised as control. Your patterns are predictable. Your motives are shallow. You are not profound. You're pathetic. You aren't special or deep, not mysterious or exceptional. Don't ever get it twisted again. No one is scared of you today. No one is intimidated by you. No one is impressed by you. No one thinks that you are important. You orchestrated this like you thought you were God. Now look at you, begging a courtroom for scraps. You spent months preparing, and still all it took was my sister in a sheath. You work so hard to seem dangerous, but real control doesn't have to prove itself. The truth is, the scariest part about you is how painfully average you turned out to be. The truth is, you're as dumb as they come. Stupid, clumsy, slow, sloppy, weak, dirty. Let me be very clear. Don't ever try to convince yourself you mattered just because someone finally said your name out loud. I see through you. You want the truth? Here's the one you'll hate the most. If you hadn't attacked them in their sleep, in the middle of the night, like a pedophile, Kaylee would have kicked your fucking ass. Thank you.
Thank you. So after all this, after Olivia speaks, after all, they all speak, all the families except for Ethan Chapins, who decided not to be here, wanted to be out with just their family today. The judge asks Brian Koberger, first asked Ann Taylor if she wants to make an argument or anything. She says no. Then he directly asked Brian Koberger if he has anything to say. And he said he respectfully declines to make a statement. And where I was sitting in the middle of the families, you know, they were just like coward, jackass. They were really, I think they wanted some kind of remorse. I mean, who wouldn't? Especially after they put their hearts out there like that during the victim impact statements. They wanted him to show some remorse. And I did too. Everybody did. You couldn't help it just sitting there. Like, finally, like, effing say something, you like psychopath, you know? Like, give these families something. And he didn't. And he didn't show any emotion either. I mean, he had this weird jaw thing that he would do that if you were sitting close, you could see. But I think that was just like a nervous tick or something. He didn't even really nod along when they were talking. So he didn't show remorse. He didn't show emotion. I can't say that I'm surprised. I went into this thinking that he wasn't going to talk. But honestly, after Olivia's speech and some of the others that were directing him, that were at him directly, I thought to myself, maybe he's going to change his mind. Maybe they did break through to this like psychopath killer, and he's going to want to say something, but he didn't. He didn't say anything. I can't say I'm surprised. And so that was it. Sentenced to life in prison, has to pay some fines, which is weird to pay, has to pay back the funeral. I don't even know if he has the money, has to pay back the funeral bills. I mean, think about this. The families have to submit their funeral receipts. It's almost like a work expense report. So, oh yeah, just submit your kid's funeral receipts. That just struck me as odd. I'm glad that he's gonna have to pay for it, but just, I don't know, can you go find the receipts and you'll be reimbursed for your kid's funeral who was murdered. The whole thing is unthinkable. And again, my heart goes out to the families. That's really the latest on today. We're expecting to get more documents probably tomorrow. And when we get them, I'll go through them too. It's a lot to go through, so it takes time, and we're going to go through the ones that came out again today just to make sure we didn't miss anything. I'm in Idaho. I'm in Boise. I'm actually going to go to Moscow. I've got a few loose ends there that I want to look into. But thank you guys for following along. I know it was emotional for you guys too, for all of us who have been invested in this case. Nothing compared to what the families of the victims are going through, not even 1%. But still, even for me as a journalist, again, I choked up today. I've become very invested in all of this. I really have. And I've become very invested in some of these families, and all the families, but especially the ones that I've gotten to know. And just like with other cases I've covered, like with Gabby Petito's case and so many others that aren't as high profile, I'll stay in touch with them. I'm not the kind of person who's just going to move on.
So, yes, I have a little crush on Brian Enton now. Those glasses just did it for me. So that was the one I watched this morning. Hi, Ames. How are ya? Not looking pretty today. I've got some nice little black bags under my eyes today. It's called I got up and went to the doctor. Came home, but it was a quick appointment, so is there anything else that we should go over before we end the live? You guys let me know. Let's see. So I saw that Brian Enton one. There are some. You're coming up. Come on up, baby. Come on up. Yeah. Declan's in the background because he's playing iPad with his sister on FaceTime. So my 19-year-old daughter is playing Roblox. That's what they do every day, is play Roblox together. And that he gets so loud. Declan, did you take your meds?
I couldn't find it.
You just said you're just trying to lie to me right to my face, boy. Go get your medication. Because I ain't gonna make it through a whole day of. I took my ADHD meds. Go take yours. This whole family has ADHD. I think that's why it's something wrong with all of us. But yeah, they. Let's see. What? Whoa! Guys, look who's here. I had to take mine. I noticed I was out. Baby girl. Are you there?
Hello.
Hello.
Maybe I can't get my camera to work. I don't know what's going on.
Are you hiding in the closet?
Hold on, it's not closed. Here it is.
Hey, don't go to Dr. Google. Don't ever go to Dr. Google. Ever.
Who's Dr. Google?
Dr. Google is when you Google your symptoms and find out you give yourself tongue cancer.
Yep, and Bonnie's gone.
Always, yeah, go to the PubMed site or NIH. There's my beautiful girl. She is at home now. Look at you.
I am at home. I had to, okay, what's happening?
I just have to say, I don't like you going into the office, and I'm going to write a letter to your boss to let them know that you are to spend days with me.
I can't get my key to work. I don't know what's happening. Hold on, please.
Holding.
Hold on. Oh, here we go.
Holding.
Here we go.
Beautiful baby.
Hi.
It's
Hi,
my other
hi.
half. It's like my yin to my yang, my other half right
I
there.
know. I even got like my work clothes on and no makeup.
Hey.
Surprise! Yo,
Presentation.
that hearing was a lot.
That hearing was honestly that hearing made
I
me
think
more.
that she is a terrible judge.
I've never thought I would say I wanted Bev back.
The thing is that she's no better than Beth, is what it comes down to. And she has not even so much as
Heather,
ruled on the evidence with property.
Heather and I are writing a letter to your boss. You're seriously impending our remote juror positions, okay?
I have to make face sometimes, and I have to do presentations in front of all of my nerdy friends.
I don't like it. And we're gonna write a letter.
I know. Me either. Surprisingly enough, I'm not a public speaker. And so even though I know what I'm talking about with my job, it's very hard to convey what I know in my head verbally, ADHD at its finest. And I get really shy.
On a channel with both of us have ADHD.
Yeah. Right.
I
and the thing that I have what's called inattentive ADHD. I don't have the hyperactivity where I'm like, I'm inattentive. And if you know what that is, it sucks.
Like that guy the other day, I was telling you about where you're it doesn't mean you're not you're hyper, it just means your brain is hyper functioning.
Right. I do not pay attention. Like people could be talking in my face and I am like I don't even hear them. And I get fixated on things that take my attention. That's probably why I'm into true crime. And other things suffer. And so when I'm nervous in front of a group of people who I know that are very experienced with my profession, it can get really intimidating. But I did okay. I did okay because I know what I was talking about. But it takes me a little while to get comfortable. That's why it's funny on here. Like I can be like normal Amy and like whatever, but general holds. I have a lot of flaws. Yeah.
I'm gonna see. I have a video somewhere of me talking to the Medicaid place, like because I finally was like,
block nose. It doesn't. It's easily distracted by fast thinking and being able to process what's happening. And so I literally like don't hear, I don't see, I can only fixate on things that interest me. And when I have a hard time public speaking, I literally shut down and don't know why. That's why I got into IT because computers make sense and I don't have to personally interact with anybody. If that makes sense.
Are you like me where you can do two things at once too?
What?
Are you like me where at times you have to do two things at once to keep your brain focused on what you're doing?
Yeah, like I'm a constant phone scroller and like I need to have a lot going on in my brain to shut my brain off because my brain is constantly going. Having ADHD is a lot like having anxiety for no reason on steroids.
Ah, well, that's me too. So we can just add it all together.
Yeah.
Yeah.
So there's that, but I did well, and I got my point across, and I was able to do my job like I always am. So you can fake it till you make it, right? But on the inside, I'm dying, and I feel like I'm shut down.
Do you have to go back? time soon.
It's why I have like a hard time with like talking on the phone to people that I'm not comfortable with. I have a hard time with a lot of different areas of my life that are directly connected to my inattentive ADHD. And I'm dyslexic, so reading from prompts, it makes it worse. So
Oh, I bet. Let me save. I want to show you a video that is me. It's not very long. We were only allowed to talk for 3 minutes. But I'm not a public speaker either.
No.
But I am an advocate for my child. And when you fucks with my child and his services because he is what do you call it? Because he is autistic and he needs the services, and you're threatening to take those services away.
Yes. See, Glock understands one thing about my friend Glock. That bitch understands me, and she knows like exactly my personality type due to everything that's happened to me over life. Over 40 years, it's been a lot. And then you add in the disabilities of ADHD and dyslexia, and the shutdown process of what all of that entails. I have a really hard time with connection with people. The internet's fine for me; it's impersonal. But I'm close to like 4 people in life. And that's okay with me because those are the people that make me feel comfortable in it.
Oh, look, it's my baby. Not what I was looking for.
There I am.
That's what I put on our thing today.
Yeah.
There it is. Okay, so this is
I love you with blonde hair, by the way.
My name is Kelly Steffi. I spoke yesterday as well at the Orlando meeting, so you might know a little bit about my son Liam. I actually have a question for everybody with EQ Health and ACA. I would like to know how many on the panel have a child with autism or has a family member or knows somebody with autism they spend time with every day. One. The reason I'm asking is because these are kids' livelihoods, and you guys who don't have any experience with it are the ones making the decisions. Liam is 5 years old. He's nonverbal. He has 2 genetic conditions that affect the same part of his brain developmentally. He has neurofibromatosis type 1 and autism. When he started ABA, he could not communicate at all. He would scream, throw fits. Angie was one of his, she was his BCABA. There was nothing. He didn't point, he didn't do anything. My son now knows sign language. My son now, if he wants something, he will come grab my hand and lead me to what he wants, and I'll say what, and he will ask me to open the drawer. He will ask me to get the things, what he wants out of the drawer. He actually communicates, and there's no more screaming. This is stuff he needs every day to live, for us as a family to live. What I want to happen is I think that along with the communication, if you saw yesterday at the Orlando meeting, there was hardly any parents in that meeting. They were all outside rallying because none of them got that golden ticket to come in. I was lucky enough to get the ticket. We need to have more parents sitting on your boards. We need to have more parents. We're asking you to help. We're saying we'll help you. Providers are saying we will help you to figure this out. Parents need to be there too. We need to have all of us together sit down and figure out what's the best way to do it, because the ones that are most important are our children.
Good for you, Mama. See, when it comes to my son, in certain topics that I'm passionate about, I can publicly speak with confidence. Because of ADHD and losing my train of thought, or saying because I need to think about what my train of thought was, and being inattentive, it's hard to like keep on track, right? And that's why sometimes our lives can go left, because me and Kelly both have that quality, right? And it can be annoying for people. The people who come here stay and they love it because they can relate to how we are. And I'm okay with how I am. However, like, you went up there and you said your piece because you love your son. Sometimes it's easier to be an advocate for somebody else than it can be yourself. It took me until 40 years old to be able to tell my big bosses that I have learning disabilities and I need accommodations. And they gave them to me and I excel. But you have to like learn how to like be okay with your limitations and then be an advocate for somebody else's. And I give you a lot of props for being able to do that and go up there. I have a friend right now that is like a huge supporter of me, like being my son's advocate, and helps me navigate that. And I truly appreciate him because he's very outspoken. And you're the same way, right?
When it comes to advocating for our kids, especially mine or my friends' kids, I almost got myself kicked out of St. Jude. Okay.
Right.
I got called into social work with the head of security to go over what I did wrong. And I responded, well, did she give you the email that I sent and that I sent that night apologizing, the 2-page email? And she said, well, no. So here, let me get that to you. I had to sign a paper to say that I would not go off on my doctors again. Right?
It's funny, like things that I am truly passionate about and I know that like I stand behind, I don't even care if I sound nervous speaking, because that's who I am as a general whole. I'm a general being. I'm a very nervous speaker because of my limitations. But I'm getting stronger as I get older. And the fact that I have my son actually makes that, because I'm not advocating for myself. I don't have like to feel bad for me because I want everything great for my son. So I am getting better at that. And watching you do that gives me hope that someday I'm going to be able to go up in front of a group of strangers and be like, no, this is not.
That meeting was actually in Jacksonville. I actually spoke also at the meeting the day before here in Orlando. And it was me and 2 other ladies that planned the rally to hang out to go, because they were doing meetings all over the state because they were talking about cutting our services. And I planned a rally with 3 other women. Those shirts I had made, people bought we had all blue with the shirts on there, and we had it out. Everyone bought their shirts. We had signs. There was 400 people at the Orlando one, and they only had 150 seats. And I somehow got lucky enough to get the golden ticket. And I went in there and it helped. I actually had 2 extra seats. So I actually was able to give them to Liam's providers, and then his RBT stayed outside with them so that I didn't have to take him inside. So I had 2 different speeches. But I that's why the second day they knew it was me again, because they're like, oh great, it's that blonde girl again. And that's why I said my first question was, where are you moving to? How many people on this panel have children or a family member with autism? Because you're making decisions for my child and you don't even experience it. You froze with your eyes closed. You there? There she is. You're moving to Haynes Creek. Are you moving to Haynes Creek?
Yeah.
Glock, are you
Glock is an amazing advocate for a lot of people.
Haynes City.
She
Okay,
said
so you'll be
City.
Haynes City.
Yeah.
So she's probably
and Haynes is a really Haynes.
I'm trying to think how far you'll be from me. You'll probably be about an hour from me because I'm on the other side of Orlando. I'm on the Jacksonville side of Orlando.
Yeah. But at the end of the day, I think we're all our worst critics, because when I got done with my presentation today, because I do know what I'm doing with my job, sometimes I just have a really hard time articulating things that sound educated, and I know what I'm doing, and so the confidence behind what I'm saying can be a miss sometimes, but I'm working on it. And my son gives me strength to be able to work on being an advocate for myself, because if I'm a good advocate for myself, I'll be an amazing advocate for him. And that's what I'm working on. You know, everyone is a work in progress, and I'm a woman of many flawed things, but I have people in my life that are teaching me to be better, and my son is included in that. And I'm very, 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 very happy and content with that. So one day at a time, kids, just like sobriety. Yeah.
Glock, you're moving to Grady Judd territory. You're going.
I love Grady Judd. Give
You're
me all the Grady Judd.
Right to Polk County with some Grady Judd. The Grady Judd don't play games. Him and the one our Volusia County Sheriff's Department. They're badass too. Like they perp walked kids that were threatening to shoot up schools as a joke.
Yeah.
And every time that they found out who it was, they perp walked them right into the jail.
Yeah. I love Jane Gordon. I wish that Massachusetts was not liberal and just put every motherfucker on blast. Put them all on blast. All the pedophiles, all the fucking everybody, put them on blast. But instead, our DA office, all of them will be like, no comment. No, you deserve to tell me what the fuck is going on in my town.
Sheriff,
Glock knows.
It's Sheriff Chitwood is who's Volusia County Sheriff. He's damn good. He's him and Grady. He's not a Grady Judd, but he's getting there.
Yeah, we need all those. We need to borrow Grady Judd for like 2 years to clean this piece of shit fucking state up. Yeah. And anywho, we don't need to talk about all this. That judge hasn't even decided on the evidentiary hearing that's going to be thrown out because of Proctorcelli and Bukaki. And from what I've read, you sent me something, a court filing, that they are fucked.
They're Oh, I told you in that court filing. I said Proctor, Bukaki.
Do you want to go over it quickly for our viewers?
Yeah, let me see if I can find it.
Okay, it's in my one-to-one message. I read it earlier. Yeah. I don't know why I can't put my camera on, guys. It's giving me a wicked hard time. I gotta figure it out.
Let's see. Also, we could talk about Blake Lively and her screwing herself. I think all that she's subpoenaed now over 45 people. Let's see.
Yeah, actually, okay. So I'm gonna tell you something kind of personal and kind of something that pissed me off. Like, I was a 39-year-old woman that got breast cancer, and it runs rampant in my paternal side of the family. And I found out I do not have the BRCA gene. It was something that happened. Even though it's hereditary, I don't have the BRCA gene. I got a double mastectomy. I came back to work, and I had a woman tell me that the reason why I got breast cancer was because of the COVID gene. Now, I work in healthcare, and during healthcare, I was a high-risk pregnancy working in a hospital that had a lot of sickness, right? And in order to keep my job, to sustain my family, I chose instead of losing my job, I got the vaccine. And I've been told more than once that I got breast cancer because of that. And I know how people feel about vaccines, and I know how people feel about all of those things, but that's not my experience. And I had a lady tell me that I should never have gotten breast cancer because it was the reason I got breast cancer, like it was my fault. It was not my fault. And people should often keep their comments to themselves because they don't know how it's going to affect other people. I got breast cancer because it runs in my family at 39, and I could have been a mother that had to leave my child if I didn't get the appropriate the appropriate help at the appropriate time. I could have been terminal by the time I was 42. And I really disrespect people who are going to tell me that because I had the COVID vaccination that I got breast cancer. I believe in people's choices, and I would never take people's choices away from them. But there's like certain comments that don't need to be said to people who get cancer or a condition that they didn't fucking ask for. If you didn't get the COVID vaccination, more power to you. That was not me. That was not my experience. And I'm glad they caught it early because I have a 4-year-old son that would have lost his mother. And I just like want to say that have I gotten Caden the COVID vaccination? No, I have not, because that's my choice, because that's my son. It's too new, but I had to get it to keep my job. And I was a high risk pregnancy, and that saving my son and having him a healthy little boy was worth, even if I got it because I got a COVID vaccination, it was worth it because I have a beautiful, healthy son today. I had that happen to me yesterday from someone at my job.
Crazy.
Yeah. So like there's certain topics that can be really testy. Do I believe in all vaccinations? Like, I don't know. I don't know if I believe in all vaccinations. Have I got my kid vaccinated for COVID? No, but I needed it because I was a diabetic with a high risk pregnancy, and my kid meant more to me than what that COVID vaccination could have done. And if it gave me breast cancer so much, I attacked it, I survived it, and I can be his mother for the rest of my life now.
Okay, so I actually went to X to find it.
Yeah, I agree. Everybody should have compassion. Like, I don't care about who doesn't get them and who does get them. I am pro whatever the fuck you want to do, right? But I won it. And if it gave me fucking breast cancer, at least I caught it early, and my son will have a mother until God decides to take me, right?
So I went on X to get it because I don't want to have to do it separately. Let me see. So let me see if I can make it a little bit bigger for you guys. Let me go to the right page. All right. Says Rule 17 summons for records. Now comes the defendant Brian Walshe. They are requesting copy of all rules and regulations for governance of Massachusetts State Police used in disciplinary proceedings. Copy of MSP policy and procedure, employee evaluation system used in disciplinary proceedings. All records of discipline, internal affairs, investigations concerning disgraced trooper Michael D. Proctor, number 3863, whereas known as Proctor from here on out, where Proctor's misconduct was sustained. All records of discipline, internal affairs investigation reports, evidence supported in support of such investigation concerning Trooper Yuri P. Buchanan, where Buchanan's misconduct was sustained. All records and discipline, internal affairs investigation. Okay, hold on, you guys. I gotta get to it. Hold on. Went too far. Okay.
Can you hear me? I can't
Yeah,
hear
I can
you.
hear you.
Hold on.
You can't hear me. Wrong one. Come on. Open. There we go. They want, why did it do that? Okay. They want reports and evidence submitted in support of such investigation concerning Detective Lieutenant Brian P. Tully, where Tully's misconduct was sustained. All records of discipline and internal affairs investigation reports and evidence submitted in support of any such investigation concerning Trooper David DeChico, where DeChico's misconduct was sustained. All records and discipline internal affairs investigation reports and evidence submitted in support of any such investigation concerning Trooper Jeffrey Kotkowski, where Kotkowski misconduct was sustained. All records of discipline, internal affairs investigation reports, evidence submitted in support of Trooper Christopher Moore, where his misconduct was sustained. A complete printout of the employees' evaluation system completed by Detective Lieutenant Brian P. Tully concerning the evaluation of Trooper Michael D. Proctor concerning Proctor's performance in the investigation in the death of Officer John O'Keefe. I said O'Keefe. A complete printout of the employee investigation system completed by Tully concerning the evaluation of Buchnick and is investigating the misconduct of Proctor's performance in the investigation of Officer John O'Keefe. A complete printout of the employee evaluation system completed in any evaluation of Proctor and Buchnick and Tully, where performance ratings were subsequently determined to be inaccurate in the subject of disciplinary action. The copy of the recordings and written transcript of the interview of Tully on July 23rd, 2024, in connection with the evaluation of Tully regarding Proctor's conduct. Copy of any records, recordings, written transcripts of interviews with Proctor, Buchnick, Tully, DeChico, Kotkowski, and interviews conducted in evaluating their misconduct in their performance of duties as investigators in assigned cases where findings of their misconduct were sustained. Connor just pulled up. And a copy of, sorry, I gotta get it over here. A copy of the non-disclosure agreement signed on March 7th, an NDA signed on March 7th by Brian Tully and federal prosecutors in connection with their investigation of the performance of state police. As grounds, therefore, the records requested are necessary material and relevant. The subject matter of the records is admissible based on voluminous and ongoing discovery provided by the Commonwealth thus far. The bias, credibility in the investigation of the allegations by law enforcement. Please. Sorry. Let's see. Yeah, I saw that. By law enforcement is a critical issue that is expected to be presented to the trier of fact. Commonwealth versus Lamprin, Commonwealth versus Waynes, Commonwealth versus Rodriguez, Graham versus District Attorney for Hampton District, Commonwealth versus McFarland. Also Guide to Evidence 1108-2024. Accordingly, failure to issue the requested summons for the requested records would result in violation of the defendant's right to due process, a fair trial, confrontation, and effective assistance of counsel, and the rights guaranteed by the 5th, 6th, and 14th Amendments of the Federal Constitution. Are 12 of the Massachusetts Declaration of Rights and Statutory of Common Law. They're fucked.
They are so fucked.
And
I want to tell you, that lady who was at Lally, I think Lally had another date today with her. Should we stream that? I think it started at 12.
Was it today?
It was today, I think.
Well, let's see. Where was it? Is it on Zoom?
I don't know.
Let me see.
Hey, look. I saw it earlier. Oh no. Emily D. Baker is going off the same one from yesterday. My bad.
Oh, okay. Yeah, he testifies again.
It's in August?
I think so. I think it's August 5th.
August 5th, yep. That's it. Emily D. Baker is going over it. My bad. I lied. I like kids.
It's Bad Kids Club. That's what we do. We lie here.
Yeah, I'm bad. I just say shit. All right.
I'm gonna start putting in our description though. If you don't like ADHD and us going squirrel over each other sometimes, then don't watch.
Listen, if I'm not for you, I'm okay with that. You should see yourself out of this fucking channel. I don't care if I got 4 people watching or 80 people watching. We're not those creators. We don't look for money. We don't look for you to fucking, like, we're just not that person. I'm not putting out apology tours. I'm not doing anything that. If you want to come here, like our regulars, like our Heather, our Stacy, our Glock, our Jay, our anybody, like you guys are all our people. You guys want to be here because you want to. And I love that for us. I love that for us, but we're not changing.
Heather says, I am here for it.
I know, right? Heather's one of us. She's my bitch.
I know.
Yeah, Heather. Yeah.
Yeah, we had a we had
that bitch.
A little nice comment left on our last Saturday's
That park block. I do everything for free. I don't want your money.
We don't want it. We don't want to make money off of people's deaths. We just want to enjoy what true crime we enjoy and go for it that way.
Yeah.
So we had a comment left on our Saturday stream by a sock account, we believe. That's what we came up with, right? With a sock account. And let's see. It said, kind of silly to live after 9 p.m. on a Saturday.
Start a voice stream. Yeah, I don't care. People can go to them after or leave us. I don't give a fuck.
We do it from 7 to 9. If we go a little bit over, his intro is 15 minutes long. Like, does it matter? It says, most people know this, but best of luck. I unfortunately don't like listening to the co-host. Just something about her. But Amy, our hearts and smiles and loves.
Yeah, fuck out of here with that.
I said, cool. Don't watch then. Thanks.
So nothing. This channel brings all the boys to the yard, and I don't hate it.
They come here to be edified.
They come here because they like listening to us. If you don't like listening to us, I promise you, I don't give a fuck. There are plenty of creators that you can go suck dick over there. You don't gotta do it here. I'm feeling feisty today, and I don't care if I got 4 viewers, 80 viewers like we have right now. I don't fucking care. I'm not about clicks, views, or getting your money. I promise you that.
It says she comes here because she's thirsty, and we got the men to quench that thirst.
Right. Yeah. Like, if you don't like us, I promise you, you don't have to tell us because we don't give a fuck.
We don't know who it was. There, it's a fake profile that was made in June. It's called FU Pay Me. That's what it says. And it's at FU 50401. So they commented on our nice little channel because they were so sweet. Yeah, go join the Angels Club. We're bad kids.
Just so you know, we'll go live whatever the fuck we want. I don't give a shit who is live. I don't owe anybody anything. We're not best friends. People go watch them, or if you want to stay here and watch us, that's okay too. Like, I'm in competition with nobody.
We do our thing and we have our fun. What are you doing? No, cooking.
All right, you guys, but I gotta roll off. I love you guys.
Do a quick dating show. That would be kind of funny. Who could we find that we could do a dating show?
I have a guy. I have my guy. Look at that. Yeah, I mean, it's just like stupid. And if you're not going to be found out, like, don't come here with your fucking hateful bullshit. We don't need it. I don't care about you.
Fucking do it with your name.
Don't hide behind a fake
Just
account.
like Matt, I had a friend, and he was like, if I'm going to talk shit, I'm going to talk shit with my real fucking name, so you know that I feel that way about you. Do I see a Steve?
No, that's Connor.
Oh, hi, Connor.
Hello.
This is my 23-year-old. He comes here and steals food.
Yeah. Typical son.
What I do best.
He's like,
You
Ma,
know, you're
all of a sudden I saw his truck pull up. I'm like, and Connor's here. He's ready to
Yeah, use your name. Like, I stand on Amy Boston. If I'm going to talk shit about you, it's going to be on the Amy Boston. Amy, you people know who fucking Amy Boston is. And if I promise you, if I'm going to get to a point where I'm spicy enough to talk shit, I'm going to have my name in my face all over that.
That's why my name is my name everywhere, because I'm not hiding behind somebody. I am who I am. And if you do not like me, oh yeah, they all come shopping at Mom's house. Actually, I will say Caleb is more or less not as much too, but that's because, you know, he works very long hours as a barber and he has a girlfriend now. And so, you know, once in a while I'll get a text from him that says, Ma, I love you. And I'm like, I love you. No, I love it when I get random text messages from them, especially at 26, that he's still.
Right.
I stay up to
Stand on your chest. You don't need a fucking stock account to talk shit.
That's who I am. That's who I am. You don't like me? Fuck off. Because guess what?
Right.
It's talk time with Amy Boston and Kelly.
All right.
Not,
I love you guys. Kelly's gonna stay up here if she wants, but I gotta go. I gotta go do my other thing that does pay me.
I don't like it, and Heather and I are writing the letter. Okay.
All right, guys. I love you. See you on the next one. Yeah.
Love you. So, guys, yes, I could tell you that our little core group of that started the channel together, which is myself and Amy and Mark. Nikki was part of that. She's in and out sometimes, so I don't even know if she knows. You got Kimmy, which is Dog Mom, and you got Mark. So me, Mark, Kim, Nikki, and Amy. We all are ones that started together, and then Maddie has been brought into that. Maddie Moe has been brought into that as well. And I will say that Maddie Moe saw that comment, and he's ready to find out who that person is and what they have to say about me. I say ain't nothing but a G thing. Snoop got it. Like, I'm not. It don't bother me. You want to talk shit, but do it. If you're gonna do it, talk behind your real name. That's all. Like, at least put your real shit out there, because anybody can be big, bad, and tough behind a fake name and a fake picture. Maddie Moe, Kevin from South Boston, that's our boy. He has the biggest heart, you guys. He is such a nice guy. And he really cares about all of us. And he saw that post and he was like, that ain't happening. And I was like, it's fine. It's fine. I'm fine. You know, I mean, the way I see it, I'm like, bye-bye, people. I don't care. Bye-bye. But I don't care. I know the people who love me and who come on our channel and hang out with us and tell me they love me and they know I love them. So today is Thursday. So we have tomorrow. I really would like to, I know I'm kind of flattered, honestly, if they want to negative comments, still give us more views. So, because all they care about, all YouTube cares about is interaction. We don't care about the views. We still have our numbers are still going up. Right now we have, how many people do we have in our, in our Bad Kids Club. Let's see. We have 1.76 thousand. So we're doing pretty good, I think. Especially since we started this right before the Karen retrial. As a little, just have fun and just be us. And I'm enjoying it. And I enjoy being with you guys every day. So I don't know if we have a trial tomorrow. We'll let you know. Just look for it. I have a feeling Maddie is on the trail. The thing about Maddie is he plays the long game. And he is very, very, very protective of us girls. And it's nice to have that. And his little bromance that he has going, him and Mark have going on, just makes my life happy. Just makes my heart happy. So, but just know that I love you guys. Oh, Maddie will. I pity the fool. Kind of going with what? Okay, I will. I pity the fool who crosses one of Maddie's friends because he don't play that game. So, I had to put in that little Hulk Hogan reference there in honor of him passing, which is just crazy. Do me a favor, you guys. I am gonna head out. Crazy. Oh, turned it on. I'm gonna head out, but if you guys are on X, and you see all the craziness that's going on with creators and people calling people out and people doing whatever, don't put that on your heart. Don't make it. I don't know how people have time for soccer accounts. I have trouble. Well, Mr. T said it too, yeah, but I think it was a Hulk thing when I was a kid. I don't know. Maybe I'm wrong. Maybe it was just Mr. T. A peaceful. But protect your hearts when it comes to social media. I ain't got time for soccer accounts. I got myself. And I can't. I love you too, baby. Have a good day. I can't. More power to them if they have soccer accounts, but the constant going after each other is exhausting. And I don't like riddles. Don't play riddle games. If you have something to say it. But for my family in here, I want you guys to know that don't get caught up in drama where people just want to pull people down, because the people who are doing things to each other are the ones that need to have a look inside the mirror and focus on what they need to heal inside their own heart. Because I really feel like people who make comments like they did on my stream about me, and about people on X, and I'm not involved in any of that. And also, those names will not be brought up in here, just so you guys know. I know, like, poor Razi, he was wanting to know what was going on with certain things, and I just don't want to even get involved in it. I stay away from it. I try not to comment or even let it get to me, because I care for certain people and other people, and but it's not my fight to fight. So I want you guys to remember, it's not your fight to fight. Stay true to yourself. And I don't know, and I don't understand the attacking of each other. I don't understand, like, I don't get it. I don't understand any of it. So stay true to yourself. Protect your heart, protect your mind, protect mental health. And remember, you always have family here. Because that's what we are. We're family. And your opinions matter. And we don't care if your opinions are different than ours. We still agree to disagree. And I mean, I just want you guys to know you guys mean a lot to me, and you guys help me get through a lot daily. Because living with a child that has cancer and taking care of a child that has cancer who most likely will be having to start chemo again in the next couple months for the third time is very hard on somebody who already has medical anxiety. And you guys keep my brain calm, and you guys keep me happy, and you keep me laughing, and you make me want to be here. So I love you, and just remember that you guys matter. Okay, hearts, hearts, hearts. I love you all so much. I don't know if it's gonna do it, but hearts. I love you. Amy loves you, my other half, Maddie, Mo, and Mark, and Dog Mom. And I know that they've all been, I mean, you know, Mark's working 80 hours a week, sleeping in a van when he can. And we're here for each other. So. I didn't see that, Heather. Bye, Glock. Love you. All right. I love you guys. I will talk to you later. Just make sure your notifications are on so you know when we come on. Love you. Love you all. Bye.
How am I supposed to say that? Talk time with Amy in Boston and Kelly. Time with Amy, Boston and Kelly. Talk 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 time with Amy, Boston and Kelly is a member, y'all. Is a member, y'all, to the Gene Deal Show. Talk time with Amy in Boston and Kelly. Talk time with Amy, Boston and Kelly. Talk time with Amy, Boston and Kelly is a member to the Gene Deal Show. Oh, thank you for your membership. Talk time with Amy in Boston and Kelly on the Gene.